Yes.
May I please, my lord?
Mm.
My lord, I beg to mention the item number 18 for upgrading the matter, because, my lord, this matter is come up for the first time, which should have been, my lord, listed in a motion stage. Therefore, my lord, this item number 18 may be taken up as last among the motion stage, my lord.
No,
Because-
anyway, after the motion, I'm taking up bail matters.
My lord.
So your matter will reach. Don't worry. You be here for some time.
Oh,
Okay?
Please, Your Lordship, I beg to mention item number 28.
20?
28, Your Lordship.
28, yes.
On behalf of Mr. D. Panging, the leading counsel. My Lord, Mr. Panging has some difficulties today. Can the matter be taken up after the break?
The vacation.
Yes.
Okay. As prayed for by Ms. So-and-so, appearing for Mr. D. Panging, list the matter after the vacations.
I'm for the
Much
state
obliged.
lawsuit.
She's there. You write that. Miss Hage was dead.
May I please, Your Lordship? Your Lordship, I beg to mention item number 24.
24.
24.
Okay.
It is pertaining to modification of her bail condition.
Huh.
Your Lordship, this matter may be listed up before the appropriate bench.
Okay.
To apply.
Huh. As prayed for by Mr. So-and-so,
Kamcha.
list the matter before the appropriate bench. Why what you said? This is for
Alteration
modification of
modification
the orders. Okay, okay. The the bench who had passed the bail order will modify
of much of that.
before appropriate bench.
May I please, Your Lordship? Your Lordship, I beg to mention item number 19, Your Lordship.
19, yes.
Yes, Your Lordship. Your Lordship, conducting counsel could not appear today, Your Lordship, due to some personal difficulty, Your Lordship.
Okay. Item 19, Mr.
E. Menjo, Your Lordship.
So-and-so states, submits that the conducting counsel has some personal difficulty and he has prayed, and as such, he has prayed for adjournment. List the matter after after the vacation.
Highly obliged.
Lordship, I would like to mention one unlisted AB for today.
Unlisted will not be possible because I'll finish these matters, then I'll take up on partner matter.
After filing of paper, matter has been maturely settled. It will take 5 minutes.
Matter has been settled. But if it is settled, police will not go after you. So do it after the vacation, immediately upon reopening, 21 or 22nd. Okay.
My lord, police is running after me tomorrow.
Tomorrow it's not possible. Tomorrow you cannot. Police will not run after you. You show them the settlement. Let it come up immediately after the vacation on 22nd of July. Okay.
Lordship, it is that's just only the misunderstanding between the complainant and the accused person.
And that will not be possible. I don't think so. It will reach today. It's already 12:20.
Tomorrow.
Tomorrow not possible. Tomorrow I'll have those fixed matters only after the vacation. Okay.
May please, Lordship. Lordship, I beg to mention item number 12.
There can be vacation benches also, no? Or you can move before the registry. Where is that? You appeared, right? You can also move before the during the vacation bench. You can move before the registry and do it. There are 2 weeks holidays. There will be vacation benches.
Only matter is actually only that check bounce issue. Nothing.
Oh, it's okay. You move it or else after the vacation. Not possible. Then.
Lordship, I beg to mention item number 12. This matter was already adjourned yesterday, but however, is again listed today.
Oh.
So therefore.
As prayed for by council, list the matter after the vacation?
Yes, Lordship. Much obliged.
Yes.
Well, Lordship. Lordship, I'll just mention to tell me matter tomorrow. To list the matter tomorrow, Moriarty.
Tomorrow this bench will not sit for long. So tomorrow there will be already fixed matters. So move it before after the vacation.
If you're not, the matter is only just to direct the registry to prepare a paper book.
Okay, then only if it is for paper book. Tomorrow.
Much obliged.
I may be allowed to make a mention for unlisted matter, Your Honor.
Today?
Tomorrow.
Tomorrow, what's the urgency?
The execution process against the cover order which we are assailing, it is initiated, Your Honor, and then the notice
See, it is initiated. It will not be done so fast. you can move it up, order before the vacation bench or after the vacation. Okay. It will not move so fast. It has just started. Don't worry. So what has happened is, Miss, yesterday, it was my mistake rather. Yesterday, I said that I will, that I'll stay that orders of the judge who had, rejected recalling of the NBW. But think over, if I stay also that recalling, rejection of the recalling order, then again NBW will come. NBW will have no effect because the person is inside, right? And recalling will also not affect since the person is inside. And moreover, the victim has to be heard at every stage. Even if you had preferred a bail application, there also you have to wait, right? Here also, I cannot pass the, because staying of that order as well as the staying of NBW will have no effect because he is inside now. So, of course, those will be, those has to be set aside. After that, bail has to be granted to you. Otherwise, there is no way out. You'll not get any effective order. So, what I'm thinking is, I'll wait for the informant to appear, and after that, the entire application has to be disposed of. These interim orders will have no effect. He'll be inside. He'll be out only when you are given bail.
Yes.
Right. So we will wait till the victim appears, and thereafter the entire matter will be disposed of. Okay.
Yes.
So for that, I have listed it for spoken to. What do you say? Miss
Yes,
Saike?
Lordship, rightly Lordship pointed out, Lordship. He can apply bail petition, he can file there also, Lordship, by recalling the order, Lordship.
This will be recalled.
Yes, Lordship.
Or of course, there are so many judgments saying that in revision matters, bail should not be granted or petition because bail has their own. You have other provisions, respective provisions for bail. So it is said, but in exceptional circumstances, even bail can be granted in exceptional circumstances. So what you do is you also file a bail application under the 438 now what it is, and then both the matters to be heard together. Two orders will be stayed, one bail will be. This is not for me to advise you, but then this should be the normal way.
Procedure, Lordship, yes.
Okay, so today I'll only issue notice. Let the victim come. After that, you get the entire order. Okay.
Obliged.
Yes. So I'll pass this judgment order in the chamber
Yes,
today
Lord.
only. Okay.
My lord, sorry to interrupt, but then with regard to my lord, item number 12, I am both a petitioner here. So without my consent, without informing me, the respondent, the victim side has mentioned the item, whereas it is the fixed matter.
What he said is that the advocate perhaps is out of station, not no.
No, he was here. It is the fixed matter. It is bail matter, my lord.
Huh?
Yesterday also, that due to time paucity, it was not reached on the time. My lord, I am both a petitioner.
Oh,
I am both a petitioner. I have no consent, no idea about, but then he has
the
mentioned.
matter will be called. In the meantime, you contact the advocate and I'll take up the motion matter.
Yes, my lord.
Okay.
Obliged, my lord.
This is revision.
Yes, my lord, this
For what?
revision is file against the judgment, wherein the accused applicant was directed to pay the check amount of 2 lakhs along with twice of the check amount of 4 lakhs. And altogether is amount to.
So today I will issue notice only. Let the respondent appear.
Yes, yes.
And your interim will be considered after his appearance.
Sorry, my lord, the case is fixed for today for report on family.
You tell the court that you have filed an appeal, a revision against that order. Okay, but otherwise interim order only upon his appearance.
If Your Honor, interim is not granted, it will become infractious. NBW will issue today itself, Your Honor, and
No, but then you tell the court that the revision is filed against the order, and give an application for staying of wait till the High Court hears the matter.
My lord, actually, the matter was fixed on the 1st of July. At the time, we mentioned that the revision is pending before the honorable bench, and the matter has been extended to the till today. So they will not consider
You
that.
say that the matter is listed for the first time today, right?
Our guarantee, my lord, here is, we are ready to pay, but what is?
Oh, there was
is-
paucity.
Yes.
Last time it did not reach.
Yes, yes,
So it did not reach. You say that today it has come up for the first time.
Yes.
And to wait for some, because unless I hear the informant or this complainant.
if such is the case, your honor, the short date may be fixed. And the interim-
Short date means today, and then it can be only after the vacation.
Yes, yes.
In the meantime, you served the notice.
Till then, your honor, yeah, interim will be granted. Otherwise, your honor, the filing of CRPC will be becoming practice, your honor, for the interest of justice. It is not
See,
like
this
that.
is state is just a formal party. Now
Yes.
I have to hear the other party.
Yes, sir. Our period is only modification or alteration of the fine imposed amount. You know. We are not challenging the judgment, your honor.
What is the judgment? On what basis you were saddled with the liability?
So actually, your honor, the fact is that the accused applicant has taken the 50,000 loan amount from the applicant. And thereafter, on default of the accused applicant, there was a sub-agreement again executed within the parties. In the sub-agreement, it specifically mentioned this sub-agreement is being executed with reference to the loan amount of 50,000 loan amount being taken by the accused applicant. And in the sub-agreement, that there was inclusion of the exorbitant amount, the exorbitant interest amount in the sub-agreement. And in the sub-agreement, accused applicant was directed to pay 4,01,000 as per the calculation of the respondent complainant. And accordingly, on default of the accused applicant, she persistently insisting the accused applicant to issue a check in security.
This sub-agreement and all, are they permissible?
So that's why, you know, in sub-agreement, the interest amount of 10% is also included in the sub-agreement.
Well, let me hear after he appears.
You know, then kindly interim may be done. Otherwise, you know, today the matter is fixed for report on
The
payment.
court already waited
Yes.
on your submission.
Yes.
And today also you say that it has been listed first, and then on the next day, the interim will be considered, and then the court will wait. Don't worry. Because I'll have to hear the other party.
Yes, sir.
Okay? I heard Mr. H. Richo. H. Richo for the
T.
petition.
Don.
Huh?
He was.
T. Don.
Yes.
Heard Mr. T. Don for the petitioner. This application is filed against the, application is filed
Judgment.
under section 438 and 442. All revision, petition, everything. 438 and 432, read with section 528 of BNSS for modification, alteration of the judgment dated 2/6/2025 for reducing the fine amount of rupees 4 lakhs passed by the learned judicial magistrate first class UPR in connection with CR number 2 of 2018 under section 138 of NI Act, Negotiable Instrument Act. Issue notice to the respondent, that is complainant. He is the complainant. Issue notice to respondent number, sole respondent.
Yes.
Sole respondent, returnable by 2 weeks. The petitioner to take steps of service upon notice on respondent number 2 by registered post with AT as well as usual process. Matter to be listed on 22nd of July. Okay,
Yes.
22nd of July.
Partial.
Yeah, 3 and 7 are together.
This on last occasion is part of now, order this on Abul Court.
Oh, acha. He was supposed to appear. He appeared.
Appeared, my lord,
Acha.
and was it on 30 May this the honorable court below. Person order will by committed the case to the court of second.
Acha.
We appeared on bail was granted, but subsequent on same that on this same order committed the case and matters fixed on 23rd of July. before the court of session. So we.
Session judge.
Yes, so if I section, item 7 petition. That is, otherwise, everything.
You are challenging the commitment.
Committed order also. Earlier we challenged the bailable warrant arrest and the for quashing the cognizance order, the search sheet and others. It was reflected. Then if only your lordship can take up this second.
Not 3, 7.
Yes.
3 has become infractious or what?
Yes, it is already infractions because the bailable warrants for bailable orders, this honorable court clarified.
They appeared and a
Yes,
case
yes,
was committed.
yes.
So as far as item number 3, it is disposed of as infractions. So right in item number 3, heard Mr.
Only
S.K. Medi.
Only, I have enclosed the or last order of this honorable court part in the earlier case, in subsequent case.
With what you want to show?
The earlier honorable court directed the API, now that order will be annexed in item 7.
Oh, that appearance order you have annexed in item number 7.
Yes, yes.
Where is that?
Page 87. Page 87 of this honorable court.
Then the
And
order of so and so,
page 92.
page
92. Annexed case.
92.
Considering the submission made the text section 304 IPC.
One second.
Yes, go.
Right in item number 3, heard Mr. S.K. Medi. And PP, who is appearing?
Yes. SPP SIT.
Oh, yes, special SPP SIT. Mr. So-and-so, your name, please.
El Kurdu.
SIT. The present petition was filed for filed for quashing of the FIR. That one you have filed also for quashing of FIR.
Yes, it was there.
Logged in. So it will not become infractious, I believe.
Same, so maybe we take together, like this maybe there.
Because
Yes.
now you are challenging the subsequent proceeding.
This, in the second petition also, that prayer is there because of this continuous. Search sheet as well as my cognizance order and the FIR also.
But what was the earlier prayer in the earlier FIR charge sheet? We have challenged everything.
Yes, ma'am.
Subsequent.
Yes.
As well as the bail warrant. It's okay, let it remain.
Yes.
It need not be
Yes.
withdrawn. So I'll take up 7.
Second.
My lord, I have a small prayer. My lord, may kindly pass over method to time being, my lord. I have misplaced some document, my lord.
Otherwise also I'll pass I'll issue notice only in this matter.
And matter this, my lord.
Actually, on last occasion, I raised objection about the maintenance of the petition.
My lord, this is
On the ground that affidavit was shown by the authorized person, not by the petitioner. That was that what I raised objection. So I need to produce one document. So that was misplaced. So that will better be possible for time being.
Even that, my lord, the subsequent petition is filed by the petitioner, subsequent petition. Even my lord, earlier, my lord, I have gone through all books and the judgments. I have not. I have not seen any judgment regarding the whether from the person concerned who shown this affidavit, he is incompetent. So in the those who have knowledge of the facts and circumstances of the case, he can sign it and show the affidavit. It is there. I've also discussed with some senior counsel of the Guwahati High Court also. So there is no such power that he cannot sign. But even then, subsequent petition is filed by the accused person. They came on 30. They appeared, and this This is also shown by them.
As
Subsequent-
far as 7, you are meaning to say that there is no maintainability issue?
Yes, yes. So-
Because they had signed it.
Yes, yes. And this recently, this I appeared same case before the Honorable High Court yesterday. This was after that.
My lord, may pass over for timing only.
This
Just
is only, my lord, is so far cognizance is without taking, without, my lord, cognizance, without,
Sanction.
That is the case, my lord. If it is there, my lord, we have no case, my lord. This also, this judgment, I yesterday after that by Honorable Guwahati High Court Principal Bench. And there is clear judgment. So, madam, we, this proceeding will be stayed, my lord. In the meantime, they will file their reply.
Here you have challenged only on the absence of sanction.
Yes,
Cognizance should
yes,
not have been
that is
taken.
the case, madam. That is the law, it is protected.
in that case,
And I have shown one is on the judicial inquiry.
He is praying for some time. So let it be, let it.
yes,
After some time,
after two, my lord.
2 I'll have.
Oh,
Pata
after some
listed.
time, my lord. Some time.
After some
My
time,
lord.
okay.
Couple of days.
Application under section 520 is crossing of the police station FI number 25 of the.
Again, settlement.
On settlement. Settlement is-
What is the offense?
Offense is on, actually, the police is alleged regarding that, 308, that, extortion. What,
Torsion.
and next is 1.7 wrongful confinement. And, 2 more sections are there, that is, voluntarily causing hurt. The FIR is in page number, Lordship, 17. This is the case of 2 girls, Lordship, that one is the owner of the restaurant and the one is the employee of the restaurant. That FIR is in page number 17. Actually, this section number 2 has even FIR before the Sadar Thana, Tezpur police.
Let me go to the FI once.
Yes. FIR is not noticed, the officer is the Sadar Thana, Tezpur, District for Assam. This is a case against which Tava engineer has accompanied for wrongfully confinement, physically assault, illegal capture of money from my father, physically harassment, forcefully, slavery, criminal force and assault, forced labor, extortion, violently, illegal seizure of my original documents, PAN card, other cards, so and so on. Attempt to murder with local criminal intention, criminal conspiracy, etc. Respected Madam, with most respectfully, I would like to start going back to register a case against Ms. Tava is daughter of the Tava, Chile, presently residing in a rented house of Srimati. Tava Monica had a near old ship on the point ground. Yes, madam, I was employed in Nagarik in York from the month of April 2024 to source of the Facebook advertisement by Ms. Tava engineer. Yes, madam, see Ms. Tava engineer, owner has fixed salary for 2 months for rupees 5,000 and after 3rd month salary will be rupees 10,000 from April 2024 onwards. Yes, madam, still the clause 1 serial number 2 as said and fixed by Ms.
She is minor.
Not minor, 19 years. Adult 19. Not paid single penny till then. The madam, instead of paying salary on time, Ms. Tava is forcefully and prudently making payment receipt signature from me. On fear psychosis, I compelled to sign signature for the salary. That madam, she Ms. Tava is on her in motive, she kept rupees 5,09,000 on my minor account forcefully. After keeping said money, she misused my minor account. What I realized today, and upon her instruction, I paid accordingly like payment of my advocate fees.
This is a joint petition.
Joint petition. Joint petition. The matter has been already settled. The case number.
But these kind of offenses.
This is actually not the offense as happens, Lord. See,
first of all, she kept some money without paying her the salary. She kept some money in her account. Although she is saying that it is minor account, you are saying that she is no longer a minor. Thereafter, she took money from the father. Okay.
Lots of there's
the allegations.
Yes,
but-
allegations. So what happened? Actually, this FIR was she was actually not interested, Lord, but maybe some family have this lead to the heart.
Let
See
me
the
read
page
the
number,
rest.
yes, page number 27 also.
1 second, I'll just read the rest of the. So many allegations against the.
But this is a case of common misconduct.
And then what do you wanted to show?
And next is that lordship. After this registration, this petitioner number 1 came to know about it, but then one ABS go in page number 23 lordship. Annex 2 before district and assessor court. So on 17th of June 2025, Honorable Court has granted accessible bail to the petitioner number 1. Page number 24 observation for the court.
Yeah.
The case diary. Page number 24, para 5, one knowledge concept for the applicant and also the copy of case diary transmitted by IO. It is also observed from the case diary that informant is yet to be appeared before the IO despite of several attempts made by IO to the phone, but the number of informant is found switched off. It is also observed that applicant is willing to join and to cooperate with the investigation of the case. Taking into consideration the fact some by the knowledge concept for the applicant is what find this is fit case for grant absolute bail. Bail was covered. So actually, lordship, after the lordship, page number 27, an extra report. What happened actually? This informant, petition number 2, actually, she was not interested to lodge the FIR. Maybe so much misleading. So what happened? FIR was lodged in Sadar Thana Tezpur on 6th of the April. So in very next day, page number 27 is application that is try to submit by
withdrawing my.
Yes, yes. It's very clear. To the officer in charge, Sadar Thana Tezpur district police person, withdrawal of 0 and 5 of Sadar Thana Tezpur GD number so and so, dated so and so. With respect to the with due respect and humble submission, I would like to inform your good office that I am withdrawing my 0 and 5 stated above as a domestic ground.
What are these photographs of?
What happened after that lordship? After granting this bail lordship, this party, they have settled the matter lordship in page number 25. Actually, this complainant and this alleged person both are like a elder sister and younger sister. But someone has missed.
They are sisters.
No, like the relationship of elder sisters.
Okay.
Not like that's owner and the employer.
What do you say?
See, the page, you have numbers of photos.
Your lordship.
That is what, not like other cases.
Yes, your lordship.
So
Because your lordship, interestingly, your lordship, my brother has pointed out that informant is not coming to record the statement. Why 0 FIR? And the second part is how they managed to enter into this agreement. This is what in Narendra Singh case has been questioned in the Lakshmi Narayan case, your lordship. That how they have entered into an agreement despite there is an FIR, 0 FIR, and not from here, from some other place, because she is not feel secure, stay here, your lordship. So that is why she escaped and she filed a 0 FIR. The presumption will always be there, my lord. And here your lord said my lord has rightly pointed out the minor account, that clarification is not there. So minor account, everything has been used. Now they are saying she is major. This is the disputed fact now. So your lordship, this is not at all a fit case wherein this the quashing on settlement will not be attracted. Lakshmi Narayan in fact will be go against this Your Lordship, the present case, my lord.
This parties already settled in outside of the court, and moreover, Lordship, they are not willing to contest the case also, Lordship. And moreover, see the photographs, Lordship, to understand this court, Lordship, page number 5, sorry, page number 20, Lordship, annexure 5.
And this I've
Yes.
seen, but the fact
This
remains,
is the recently photograph of the case.
this is not a case which will come within the
Lordship,
parameters that is enshrined by the Honorable Court. Because see the allegations, first, whether she is a minor or major, we don't know.
no,
That is for the court to decide.
Lordship says major. So in that case, that the case diary can be called. Through the case diary, this honorable court can be court can know that she is a minor. But we are submitting that she is adult, 19 years.
Okay, let the case diary come.
Yes,
We'll
yes.
have
after
some
that,
further.
the court can-
Okay, this is an, I've heard Mr. So-and-so and T8 for the additional public prosecutor. This is an application filed under section 528 of the BNSS 2023 for setting aside and quashing of the Itanagar Women's Police Station case number 25 of 2025, registered under section 308 subsection 2, 127 subsection 4, 115 subsection 2 and 146 of the BNSS 2023 on the ground that settlement has been reached between the parties by registered deed dated 23rd of June 2025. The petitioner, the counsel for the petitioner states that that the FIR may be quashed no, don't write that. It is noticed from the contents of the FIR that the victim has alleged various allegations against the accused person, such as the accused person has kept her as an employee to work at Naga Kitchen on the promise that she'll be paid a monthly salary of 5,000 in the initial for the initial 2 months and 10,000 thereafter. However, no money was paid, and that the accused person had, on the other hand, kept money on her minor account forcefully. And from that money, the accused person used to make payment of advocates' fees, shopping money, etc. The victim also alleged that the accused person used to make false and fabricated stories that she steals money from the accused person, and that the accused person used to forcefully threaten her father to pay the money. It was also alleged that the victim was subjected to physical assault by the accused person. And also that the accused person took her and accused person accused person along with her brother took her to some other place and kept her confined for 7 days, and and by using physical force made her work in the restaurant. Victim further stated that various false videos were also made as such discord. Is constrained. Full stop. Looking at the allegations made in the FIR, this court is constrained to look into the investigation done by the police in respect of the aforesaid case. Call for the case diary. Fix the matter on 28th of July.
Yes, madam.
28th of July, 2025. Okay. After that.
Obliged. Deeply obliged, madam.
My lord. My lord, this application is filed under section 528 of BNSS for quashing and setting aside of charge sheet number 43/2018 under section 392/34 of Indian Penal Code, arising out of the FIR dated 3/8/2017.
Where is the FIR?
Yes,
Where is the FIR?
FIR is at page number.
There are 5 number of accused person.
Yes,
Okay. Show me the FIR.
FIR is at page number 19.
Yes.
Type copy is 20.
Okay. There is stealing of 2
Yes.
cartons of cigarettes
Yes,
amounting to 1,75,000.
yes.
Then what is wrong in this?
My lord, here the petitioner number 1, the applicant number 1 is a complainant and rest are the accused person in this.
Oh, again settlement.
Yes, these are the settlement.
Okay.
Same order may be passed, madam.
Let's see. What about the charge sheet? Same things.
My lord, kindly see the settlement agreement.
Charge sheet. Let me see the charge sheet first.
Page-
Okay. I've
page
got it.
number
Page
23.
27. The boys were under the intake of alcohol and they voluntarily attempted to fear the driver. Excuse me. No, the cases like family natures, like those civil disputes, those are settled. Here you see 4 persons intoxicated, they robbed a vehicle, took over this. Hey, if these
Yeah, ma'am.
all these matters are settled, then
Yeah,
what
ma'am.
will, I mean, the
Yeah, ma'am.
culprits will get an
Yeah,
opportunity.
my lord, there is purely a miscommunication between the parties, my lord.
And this is
Here,
written by what?
here the petitioner number 1 and the rest accused were not, they were known each other. But due to due to only the mistake of driver,
Let the case diary be seen. Let
due
the
to
case
only
diary.
the mistake of driver, this
Whatever,
FIR
see the contents of the charge sheet. The driver prior to the primary stopped them, intake and they voluntarily attempted to fear of instant hurt. The driver prior to escape made made from the place of occurrence saw boys out of the 4 cars who got off vehicle and were missing. On arrival, this charge sheet is also not proper. You have not annexed proper. This is illegible. All these words are missing.
Right.
Part of the incident with driver happens to no one except for his name, which eventually led to the arrest. Whatever, I mean, let the case diary come. Heard Mr.
My lord,
Sullivan-
TCR.
Oh, TCR, yes. What? The proceeding is on.
Yes, charge sheet file, my lord.
And-
Now,
Charge sheet is filed.
now it is for
Committal
committal inquiry, perhaps committal
That's
inquiry.
much committed. TCR along with the case diary. Heard Mr. So-and-so? Anti-ATA? Yes. This is an application filed under section 528 of BNSS for quashing and setting aside of the charge sheet number 43 of 18 under section 392 of 34 of the IPC, 392 read with section 34 of the IPC, arising out of the FIR dated 3/8/2017 in Pasighat Police Station, case number 131 of 2017. The counsel appearing for the petitioner prays for quashing of the charge sheet as well as the charge sheet as well as the subsequent proceedings on the ground that settlement was reached between the parties by deed of amicable settlement dated 29th of June 2025. However, it is noticed from the charge sheet mentioned above that the instant case relates to a serious offense inasmuch as the petitioners stopped the vehicle of the informant near the market area. The petitioners who were intoxicated stopped the vehicle in the market area and robbed two numbers of cigarette cartons valuing to rupees 1,75,000.
My lord, sorry to interrupt. My lord, we have already compensated the amount of the cigarette.
Whatever it is, this is not a case for quashing. You will rob people there and then these are allegations. Let the trial go on. Okay, call for the case diary.
Along with the TCR.
Yes, call for the trial court records along with the case diary. Release the matter after 2 weeks on a date to be fixed by the registry.
My lord, the interim may be, my lord.
No interim. It will be seen after the case diary.
Let it be on 29th, my lord.
29th of
Yes.
July.
Okay. Oblige.
Interim to be considered on that day. Or it can be not required. It can be finally disclosed of.
Yes. Oblige.
Much obliged.
Hope this is not settlement again.
This is settlement, your lordship, but what the parties paid has been marital discord here out of.
Huh? What is the FIR? This is a joint petition.
Joint petition. They were husband and wife.
Oh, okay. It's the husband and wife. Okay. Something can be considered. What is the FIR?
The FIR, your lordship, it's in page number 20. The entire allegation is basically that the accused person had extramarital affair and then subsequent those were the cruelties meted on her. That was the allegation.
Let's just go through once.
Yes, your lordship.
The allegations are serious, like extra went and he also threw his mobile on her face and all.
Those are the allegations. Now, as of now, the agreement which was settled between both the parties, the reason is that this is of 2017, Your Lordship. 2017, the cases of 2017. Now, both the parties are subsequently married to their respective partners and have their own families. That being the
Oh,
reason-
they are no longer husband and
No
wife
longer
now.
Husband and wife. So
They have divorced.
they have mutually separated, and both the parties are now respectively married to their own partners and have children.
Okay.
That's why they do not want to.
Accused is married to the same lady that he had or some other.
Some other, and
Some other.
she is also married to some other person.
Some
and
other.
Both have children.
This FIR is filed in December only.
2017, Your Honor.
Yeah, in 2017.
Yes,
And where is the settlement?
settlement, Your Lordship.
What happened after this FIR? Charge sheet is filed?
It was charge sheeted, then the charge
Trial.
was framed, Your Lordship.
Ah.
So during the pendency of this case, Your Lordship, then
Trial was on.
trial was on, only the charge was framed.
Hmm.
Then it was subsequently for the evidence which has not yet started.
Okay.
So in the meantime, they have mutually settled the matter.
What do you say?
Well, Lordship, with regard to the settlement, I have no objection, but in their affidavit, Lordship, I have doubt over their signature, Lordship.
Acha.
They are the resident, the capital region, but they notarize their.
Purnima
trust-
Dongong Rijizu, her signature and Fangshas.
Yes.
Why are you doubting by seeing the affidavit? No, match the signatures in the affidavit and the.
No, Lordship, page number 51 and page number 17. Kindly, page number 17 is the affidavit, Lordship.
Page number 17.
Yes, Lordship.
This
50
is
the
Kya Fangsha. Kya Fangsha.
signature of the petitioner number 2, Lordship. Oh,
Kya Fangsha seems to be same. And the other one. Oh, this is a joint petition.
Joint
Yes,
petition,
it
Your
is.
Lordship. And the agreement was done in the house of the petitioner number 1's sister, Your Lordship. So in the Itanagar, now she is married, she lives somewhere, they have to come down to Itanagar and they can agree.
If this is the fact, like dragging the old issue and appearing in the courts will not be very fair if they are married to respective parties.
yes.
And also, if your Lordship will see evidence again, they have to face each other.
Hmm?
In the stage of evidence,
Ah.
both the parties have to face each other. So that will not be convenient. And also, it is very much within the purview of Lakshmi Narayan case, Your Lordship, because this is out of a marital dispute. So since the matter has been spelled, we need not take on to those past.
This is a matter.
Yes, I have no.
Why are you disputing the signatures?
Since the signature, it appears, Lordship, the
No, but
signature are
then
copied,
Yeah.
copied one, Lordship.
But then see, the lines and the straight lines and all are there. And we are not fingerprint expert, we
No.
are not this, but then
Me
we are
neither.
not his signature expert, but then it doesn't seem that they are very different. See?
I leave it to your Lordship.
Sorry. Whether you want to see the case diary over. Now that is in
It's
the
not
trial
required,
stage.
Lordship.
Okay. I heard Mr. Because see, now they are separately married. This will not be
Yes.
fair. I heard Miss so-and-so. This one I'll pass it. Pass this one. Heard Miss so-and-so for the petitioner. You are Miss
R. Taku, Your Lordship. R.
R. Taku.
Yes, sir.
Miss R. Taku for the petitioner, as well as D. Loy, the public prosecutor for the state of Arunachal Pradesh. This is a petition filed by the filed under section 528, right? It's the section 528 of BNS for quashing, setting aside of the charge sheet number 75/18 of Itanagar Women Police Station. And the file for quashing of the FIR dated filed in connection with the FIR dated
17/10/17.
Yes, 17, right?
10.
Filed in connection with the FIR dated not 17.
7/10/17, Your Honor.
Okay. Yes, 6/10.
6 was the FIR, then registered on 7.
FIR dated 7/10. 2017. They registered under section 498A/420/344/323/506 of the IPC. This is a joint petition filed by both the accused person as well as the informant, the victim. The case of the prosecution is that the victim stated in the FIR dated 7th of October 2000, dated 6th of October 2017, that she was mentally and physically harassed by the accused person, that is her husband, since the day of her marriage. She stated that the accused person does not return home at night without informing his whereabouts, and she came to know that he was addicted. He had a bad habit of addiction in gambling. She later came to know that her husband had a long-term relationship with another lady having twin children, which was stated to her by her sister. And that one fine day, that is on 22nd of September 2016, she got a phone call that her husband's car is parked at a particular place. And when she went there, she found that the husband was in a house where a lady was also there. And she saw both her husband and that lady sitting in a comfortable position as if they are husband and wife. She thereafter stated that she was humiliated and she was sent away, and that she left for her matrimony. She left her matrimonial house, and that she left her matrimonial house. Miss So-and-so, appearing for the petitioner, however, states, before that, the case was registered by the police under the aforesaid sections, and the charge sheet was submitted, and the charges were also framed. Miss So-and-so, appearing for the petitioner, states that the dispute between the husband and wife was settled by deed of an agreement dated 28th of December 2024. Full stop. The counsel also submits that now both the petitioner, both the victim and the accused person who are petitioners in this petition are respectively married to other parties, or what do you say? Are respectively married to other parties and are living a peaceful life. Before that, you can write both the parties have mutually agreed for separate. They are mutually living separately and are married to other parties. Okay. heard the counsels. On the other hand, the learned PP submits that what?
Their signature in the affidavit.
Oh, yes. Submits that he has doubts with respect to the deed of agreement entered into the parties in
Not deed
view of the
the-
fact
Yeah.
that the signature of the husband, right?
Both,
The
the
accused
both,
person.
both the lordship.
No, where will you check the other, the signature of the lady is also there in the affidavit?
Yes, lordship. Both the signature, both the applicant signature, lordship. That's why I raise objection, lordship.
Where there is signature of only the husband, he has filed this on. behalf
Page
of-
number 15 and 17,
Okay,
lordship.
okay, deponent, huh? This is, first party's name seems to be little different. No,
In that case, lordship,
And-
instead of disposing this matter, let both the party appear before this court and
but then I don't think so, the signature is that different, just check it again. Only that P is little unconnected from the A.
and the line, lordship, after saying,
Line is there.
That would be very surprising. We are checking the lines and dots here, lordship.
It's as if we are the signature.
Yes, your lordship.
We
Otherwise,
are the
it's not-
handwriting
it's already been
experts.
settled in.
This is a joint petition they have
Yeah,
filed. Let's see what happens. And then, okay, he states in view of the fact that the signatures appearing in the deed of settlement and the affidavit filed in the instant petition seems different. And also that for the ends of justice, no, not required both of them. Okay, different. I heard learned counsels and have perused the records. It is a settled proposition of law that in cases of family disputes or of financial transaction or of civil disputes, cases can be quashed on settlement, as has been held by the apex court in a number of decisions. However, in cases of serious nature, such as murder, rape, etc., the cases cannot be quashed in view of the facts therein. In the instant case, it is noticed that the dispute was between the husband and wife, and the FIR was lodged way back on 6th of October 2017. It is also noticed that, and it is also the submission made by the counsel for the petitioner that both the parties have agreed to stay separately and that they have married to the respective parties during these years. It is also settled by the Honorable Apex Court that cases where there are no chances of conviction or will be an abuse of the process, the same can be settled between the parties and the respective proceeding can be quashed. In the deed of settlement, it is, which was entered into, in the deed of settlement which was entered into on 20th of December 2024, it is written that the marital discord arose between the parties when they were husband and wife, mainly owing to the allegation of an alleged affair of the husband with another lady. And that the said marital discord was due to the misunderstanding. And further considering the further considering the larger family interest, both the parties have mutually agreed to settle the case. Full stop. The parties have agreed to bury the previous discord and have promised to maintain cordial relationship with each other. And they have also decided they will file a joint application for quashing of the criminal case, which is the present application. Full stop. Although the learned PP has raised the objection, has raised doubts about the authenticity of the deed of agreement by looking into the signatures of the parties, but a bare perusal of the same and matching the said signatures with the affidavit filed in the present case does not seems to be different. Since this is a case related to a family matter where the husband and wife had settled a dispute and are married to the respective parties, this court, in the further interest of the in further interest of justice, quashes the FIR dated FIR dated
7/10/17.
2010, right? No, what?
7/10/17.
1710
7/10.
or 710 2017, as well as the charge sheet dated what is the charge sheet is dated?
Dated 4/8/2018.
Charge sheet, where is that?
Page number 24, Lordship.
24. Charge sheet, yes. Charge sheet dated 4/8/2018, as well as the subsequent proceedings. Full stop. The criminal petition is disposed of.
Duly obliged.
Oh, I could not take up your matter no, after some time, but
Yes, Dr. Anand. Yes,
But then at 2 o'clock, I have a parted matter. So,
my lord, is only last occasion, he was asked whether prosecution sanction was has to obtain or not. My lord. That was my query of this court, my lord. That was also, so that part is there. My lord. It is
okay, let the council come
Because-
after the parted matter.
because only 5 minutes, he also may not turn up, my lord, as per this.
Okay, after the parted matter. Parted matter will not take long, half an hour, 1 hour or so.
Your Lordship, my matter is item number 11. It is a bail matter pending since 1 month, Your Lordship, before this court.
11.
11, item number 11.
11. You can wait, I'll take up the bail matters. I'll not take long. The parted matter is only for matter.
Yes, I will one offense. Yesterday, madam, this matter was dismissed for order matter. This is from CR to pending matter. Tomorrow, this matter is only for order for the states.
Tomorrow I'm going. I want to go early. Now, what is the urgency?
Urgency, there is also very urgency that matter because there is also one stay order passed by the senior division that has been put to challenge in the CRP.
Acha.
So, stay is complete. Tomorrow that has to be on the record and then matter will be fixed for revision.
Then again, you'll pray for interim.
No.
Acha.
Tomorrow only for states.
Okay.
Nothing.
There are already many matters. Do it before the vacation bench.
Only for states. Nothing, madam. Only steps of the steps of 3 and 5 have been done. That has to be reflected.
Okay, within 1 hour I'll finish. What can I do?
Much.
Yes, Mr. Majumdar, I'm sorry for not giving you much time.
No difficulty, madam. I'll be taking even less than half an hour.
Actually, what happened, I made it parted. And
I
then tomorrow I'll be leaving. And then
Yes, ma'am.
I'm allotted Kohima and Mizoram bench, Aizawl bench.
Your lordship will be on the run.
I'm on the run. I'm already on the run. So I
Yes,
wanted to. So finish it as soon as possible. I've
My
already
lord,
heard it.
within 15 to 20 minutes, I'll be able to complete.
Oh, okay. I'm so obliged to you.
My lord, my lord.
Yes.
My lord, as
Yes.
your lordship has heard my learned friend appearing for the appellant,
Huh?
here is a case, some election of an organization,
Yes.
which is actually a federal body, and there is an apex body called APSU. And AKKDSU, I think, is AKKDSU. Yes, this is the federal body. Some election was held prior to the date on which allegedly the election was held. There were some issues, and the deputy commissioner intervened and said that don't hold any election. Thereafter, till 27th, there are notifications by the deputy commissioner not to hold any election.
I've seen all this.
Because yes. And then 27th, there is another notification by the chief election commissioner appointed by this organization itself, again to hold the election on 28th and 29th, the following 2 days. And according to them, the election was held, and since nobody participated, they were declared uncontested. That is the case.
Yes.
So far as the plaintiffs, respondents for whom I am appearing before your lordship are concerned, my lord, their case is that on 28th, actually no election was held. As a result, the result which according to them is declared should not be allowed to prevail, and therefore they have prayed for a temporary injunction restraining them from functioning, etc., etc. That is the case in a nutshell, my lord.
Yes.
Now, before I go to the impeachment order, my lord, I'll just show 2 paragraphs, allegation of the plaintiff and their reply, and then I'll take your lordship to the relevant part of the order. That will be the end of my argument, my lord. Lordship will straight we go to paragraph 10 of the my lord, plaint.
This
Which
is
your
an
lord-
item number
It's
04.
FAO 5 of 2025, my lord.
5.
My lord. The other one your lordship is already heard.
Yeah, that one is
That,
finished.
that is by a different group but challenging the same election. My lord.
Yes, I'll just take out the plaint. Yes, plaint.
Yes.
Yes, which paragraph?
My lord, lordship may straightway turn to page 47, paragraph 10. Here, lordship will find, if your lordship comes with the paragraph, my lord,
Yes.
that the plaintiffs beg to state that they, being bona fide and genuine aspirant candidate who believe in free and fair election, have suggested the defendants number 1 to 4
for having some patience and to find a suitable place for holding election with the due permission from the concerned district administration. However, hastily again the defendant number 1 issued another notification dated 27/9/2024, wherein he fixed 28th and 29th September 2024 to hold the 7th general election 2024 of AKK DSU at so-and-so office, Colonial. However, since the AKK DSU office Colonial was guarded by the police personnel on 28th and 29th September 2024, election could not have taken place, neither there was any registration of voters, delegates taken place. This is their allegation in a nutshell.
Yes.
Now, Lordship will kindly see what was their reply, because that is at this stage, my Lord, since the trial is yet to take place, Lordship will have to decide on the basis of affidavit allegations made in the plaint based on affidavit, supported by affidavit, and their reply.
Yes.
Their reply of this paragraph, your Lordship will find at page 161. Page 161, para 13, my Lord.
Yes, paragraph 13.
My Lord. Except for the notification dated 27/9/2024 issued by defendant number 1, answering deponent vehemently denies the remaining averments made in paragraph 10 of the plaint under reply. It is specifically denied that Akadasu DSU office was guarded by police personnel on 28th and 29th September 2024. Moreover, the question of voter registration did not arise as the process of delegate registration had already been completed and the process for filing nomination papers was scheduled. Following the revocation of the earlier prohibitory order dated so-and-so and so-and-so, issued by the Deputy Commissioner, defendant number 1 issued a fresh notification of 27/9/2024, specifying the dates for issuing and submitting nomination papers by contesting candidates for voting. This was duly notified to all the concerned through wide publicity to enable participation of all aspiring candidates in the election process. Pursuant thereto, plaintiff number 1 and other aspiring candidates being defendant number 5 to 13 and 32 to 33 submitted their nomination papers for various executive posts, and accordingly, Lordship will kindly see now. In the absence of rival contenders, all of them, including the plaintiffs, were declared duly elected unopposed to various executive posts of the Union wide election result dated 28/9/2024 by defendant number 1. The election result was published on 29/9/2024 in the local daily newspaper, the Arunachal Pioneer. It is reiterated that due to absence of the rival contenders, no voting process took place on 29/9/2024, and the election result was declared on 28/9/2024 itself. Until 2 p.m. of 28/9/2024, no nomination papers were received from any rival contenders, etc. This is the reply. Now, your Lordship finds in the reply itself, they admit many things, including that the plaintiffs were not present there, number 1. Now, your Lordship is aware, is a basic thing in the Civil Procedure Code, that mere denial will not do. You will have to state what is your case, but here they are simply denying that no, it is denied. But if there was a normal election held on 28th, then there should have been a clear averment that yes, on that day you did not turn up on your own, but situation was normal. So-and-so has come, and see, in the presence of so many persons. And so far as the Deputy Commissioner is concerned, my Lord, I'll just now show, Deputy Commissioner has specifically passed an order that she don't hold any election on 28th and 29th. In spite of that, and that order was passed by Deputy Commissioner on 27th. And 27th, there is another notification by the defendants for holding the election on 28th and 29th itself.
There are two, in fact, notifications on that day.
On that day, I have seen, I'll come to that, my Lord. In fact, the first notification was to hold the election if everything is normal. And then second notification is that please don't hold the election.
Now, which is first and which is second?
Yes, your Lordship is absolutely correct. Now it has to be ascertained. I do not know what is the averment of either of the parties. Which one is first? My instruction is first one is by which it was allowed. Second one is the one by which it was again stopped. But I'll go to that a little later, just because I want to complete very fast manner. Lordship may kindly turn to page 74 for a moment. Everything will be clear, man. Page 74 is the notification based on which the election was held.
Yes.
Page 74, Lordship will find
Hmm.
27th of September 2024.
Yes.
It is to notify all the bona fide students of Kurumkume district and aspiring candidates that 7th general election so will be held on 28 to 29. Now they have given a schedule also.
Yes.
28, my lord, election will not be held. 28 is the date meant. Of course, normally, as your lordship is aware, first day is kept for nomination, second day is kept for withdrawal, as far as scrutiny, then a date for withdrawal, then a date for publication of list of validly nominated or those who validly submitted their nomination paper. Thereafter, the date is fixed for election, if it is a normal election.
Everything done in one single day.
In one single day, and now on top of it, my lordship will kindly see in this schedule, the second part of the table says 29 September 2024 is the date for starting the voting process, followed by counting and declaration. So declaration, voting, counting, everything has to take place on 29th. And 28th is the date fixed only for declaration of validly nominated candidate. Now, their averment in the written statement is clear that see, everything was, as I have shown, my lord, I'm just repeating, one page 162 once again, my lord.
162.
My lord.
161. Yes.
161 and the bottom part 161. In the absence of rival contenders, all of them, including the plaintiffs, were declared duly elected unopposed to various executive posts of the union, while election result dated 28/9. How could it be declared on 28/9, my lord? Assuming that there was no other candidate, that can be done only on 29th. It was done on 28th September itself.
One thing has come to my mind, of course, that RP Act is not applicable.
Oh,
but
yes,
then
ma'am.
if we take recourse to that, if we see,
My lord.
bring the analogy,
My lord.
there under section 53 subsection 2, it is said
My
that
lord.
if the number of posts are same
Yes.
compared to the applying candidates,
Yes.
then the returning officer will, without any delay, issue the results that they have won.
Always, my lord. But here is a case where your lordship is in there, themselves have said that there were even the plaintiff was also elected. Now, here is a case. Now, due to absence of rival candidates, he will declare. But on which date? Declaration date is given 29. 28. Why you're in a...
But since there are no other candidates, nominations, there are no averments also that they went to file nominations, they were not allowed. In absence of nominations, and there are only those candidates. So 28, when the returning officer got, he declared the results.
In a normal, my lord, your lordship is absolutely correct. In a normal case, if there is no other contesting candidate, he can declare. But here is a case when on the same date in the morning hours, every hour there is a new event to take place for withdrawal, etc., etc. Then the result also published on the same date. On top of that, my lord, when there is a specific allegation that it was absolutely abnormal and election was not held at all. And your averments made in the plaint earlier to that will show, my lord, because of the law and order problem, Deputy Commissioner had to intervene. And now I'll show your lordship why the Deputy Commissioner had to intervene, my lord. Lordship will kindly straightway go to page 68, my lord. That is the first, my lord, order by the DC. My lord, page 68, my lord, first two paragraphs, lordship will kindly see about the election process, etc. Then, third paragraph, and whereas there is apprehension of breach of public peace and tranquility which may lead to unpleasant law and order situation in Itanagar capital region, now therefore the permission given to C. So-and-so for 7th general election to conduct election process as so-and-so is cancelled.
Cancelled, yes.
And these are all admitted positions. He has cancelled. Now,
on 24th.
On 24th. Now, page 73 is the letter.
Yes, this is where again this is the
tussle. Yes, this is the tussle. This is the second letter. Before that, my lord, that 184, lord, should you kindly see. In the morning hours, this order was passed at page 174.
Yes.
Same day.
Same day.
Saying
27, 27,
same
and
day.
they talk of the meeting on 26th.
My lord. And then last paragraph says, therefore, the order is so and so 26th September 2024, which I have just now referred, issued under section 152 BNSS and passed by this office stands revoked with immediate effect. Then, unless the present evidence clarifies that this page 73 order is a prior order, they cannot say, because DC will come and say, no, this is a subsequent order. Because of the law and order problem, page 73 order was issued subsequent to the page 184 order, saying
But-
that,
Hmm.
my lord, you
No,
also
no, no, you continue. It's
yes.
okay.
Madam, page 73 says the election notification issued by the Chief Election Commissioner of upcoming 7 general election, etc., dated 25/9/24, regarding holding 7 general election of so and so on 27th and 28th September shall not be held as discussed in the meeting dated 26/9/2024 at DC Conference Hall, Kalori.
But then see the contents.
My
Here
lord.
they are speaking of the DC's order on 25 election commissioner's order on
My lord.
25/9/2024. They
Yes.
did not speak about the 26th meeting.
No, it is
This-
said as discussed in the meeting on 26th September.
As shall not be held as discussed.
Yes.
But 26/9 at
Yes.
so and so.
My lord.
Yes.
But what I am trying to just impress upon your lordship is,
Mm.
when there is an order of 27th September 2024 saying that 27th and 27th, please don't hold election.
Mm.
Now, on 27th, same day you issue another notification. And even if we go by page 184, on which reliance will be placed by the appellant, even then there is a third paragraph says that, and where they after fair discussion during the marathon meeting, all the stakeholders of the upcoming 7 general elections so fully assured to maintain peace, order, and tranquility in case of holding of the aforesaid event.
In case.
Now, in the background of these things, my lord, it is for the persons who are holding the election to come up clearly to say that, see, everything was normal, all participated, voters participated, there was normal nomination. But it is not necessary that only the plaintiffs wanted to participate and wanted to submit their nomination. There may be others also. It's a student organization of a huge body. Where is the averment that everything was normal except the plaintiff? Nobody else was prevented, and everything was normal. There's nothing like that. This is one part of the matter. There's other part of the matter.
Another part in this 27th order, they
My
speak of election on 27 and 28. Whereas
Exactly.
The dates were later changed to 28 and 29.
Exactly, my lord.
Why were the dates changed? I mean, to 28 to 29? Who changed the dates? There was something. Appellant number 1, I think.
Yes, my lord. 27, page 74 also will find. Page 74 is the notification whereby 28 and 29 was fixed. So everything was done hastily. That is the allegation of the plaintiff, my lord. So that is why, my lord, and so far as the so far as the balance of conveyance is concerned, my lord, straightway by this election, they cannot do anything. After that, they have to get approval on the own showing of the present appellant by in the written statement that they have to take approval from their parent body, that is APSU. So before that, there is no question of oath taking, etc. It is their case. So in that view of the matter, possibly, my lord, there is a case where the appellants have been, as respondents, plaintiffs have been able to show that the declaration was absolutely illegal. This is one part. Secondly, my lord, now lords will kindly come to the impugn orders. My lord, the impugn order is at page 26, my lord.
Yes. We'll refer to 110 order. 10.6 is the absolute order.
My lord, first order is 110, that is the detailed order. And on this order, on this date, it was only made absolute. So we'll have to read both the orders together. I'm just pointing out one thing. The 1/6 order is in page, my lord.
26.
142, my lord. It's a detailed order, my lord. I have just read it.
Yeah.
In this, my lord, the page 146.
Yes.
page 146 at the bottom paragraph, my lord, after hearing the learned counsel for the plaintiff's petitioners and perusal of the case records, I found a prima facie case that the proposed 7th general election of so-and-so was not allowed to conduct by the learned Deputy Commissioner, Capital Commissioner, as well as the Deputy Commissioner of Kurumkir District by prohibiting the defendant respondent number 1, Chief Election Commissioner. But despite prohibition order, the defendant respondent number 1 issued another notification on 27/9/2024 for conducting election with effect from 28/9 to 29/9. From the record,
This is actually what I wanted to show you, because Chief Election Commissioner had again issued a notification on 27/9 for conducting election on 28 and 29. And the order of the Deputy Commissioner was in respect of Chief Elections Officer's order on 25/9 for holding election on 27 and 28. There is a difference.
Yes, ma'am. This is one. Now, yes, ma'am. So, thereafter, the next sentence in this page 147 says, from the record, there is nothing to show that the election was conducted in person to the said notification issued by defendant number 1. Rather, there is a cancellation or prohibition order passed by the Deputy Commissioner with a direction to the Superintendent Police for him to execute and implement the same. Therefore, I am of the considered view that the prima facie case has been made out against the impugned unnumbered and undated declaration of result, which is further clear from the instance suit itself, as the instance case has been filed by the plaintiff petitioner who also have been declared as elected unopposed in the impugned unnumbered and undated declaration dated so and so. Now, my lord, so far as the lordship has heard the other case yesterday, but I am not appearing in that case, but since there is a reference of that case and the present impugned order has been passed primarily based on the earlier order passed in that case, my lord, from there, if your lordship finds in the prima facie case of that judgment, there is a clear finding that I am of the opinion that there is reasonable and genuine legal issue that deserves judicial attention, because from the record, there is sufficient evidence indicating that 7th general election of so-and-so was conducted on 28/9/2024, yet results were declared on the same day, which violates the election rules and regulation that breach of legal rights of the plaintiff petitioner, hence there is a prima facie case. This is what I was trying to project.
You are reading 5/5 order?
Madam, I am reading the order, 5/5 order, my yes.
Yes, okay.
So that is the finding there. Now, my lord, one very important aspect I have to highlight before your lordship. In the present impugned order of 10/6/2025, although the earlier order passed as ad interim was made absolute, but then, my lord, lordship will kindly see page 27 and 28. It is primarily based on the 5/5 order.
Yes.
Because the learned court has recorded a finding that the same election was put to challenge by another group of students. And in that suit, there is already an injunction order.
That is one.
And that is why I am also, yes, yes. No, not 110, 5/5.
Yes.
5/5. Yes, page 27 and 28, the learned court has recorded. Another case was filed before this court by some of the intending candidates by challenging the same election result, wherein this court has granted temporary injunction by order dated 5/5/2025. After hearing all,
where are you reading?
Page 27 of this memo of appeal, my lord.
Yes, which paragraph? Yes, I've got it. Yes.
Yes, my lord. Yes, some new development, not we have seen. Some new development has been taken place as another case was filed before this court by some of the intending candidates. So this court has granted temporary injunction on 5/5/25 after hearing all the parties, and the same were also challenged before the High Court, etc. Then right hand side, my lord, will kindly see the last paragraph. I also heard so about 7th, 8th line from top. The temporary injunction granted in title suit number 7 of 25 while disposing of so and as such, I am of the considered opinion that the injunction order dated 1/10/2024 deserve to be made absolute to prevent frustration of the very purpose of the suit. So primarily, that same court has passed an injunction in another matter, taking a cue from that, and the earlier order passed as interim measure, my lord. This order has been passed. Now, the 5/5/25.
Whether that is permissible.
Well, I am on a slightly different. Your lordship is absolutely. That is what I am coming to, my lord. Now, when this order has been based on the earlier order passed as ad interim, number 1, and number 2, in the same matter, an order has been passed or in the same election dispute, my lord, on 5/5/25. So this court has said that I am privacy, I am satisfied. Now your lordship has heard an appeal against the order dated 5/5/25. Possibly, my lord, subject to what my learned friends say, possibly, my lord, the result of the judgment your lordship will be passing in the other appeal where the challenge is made to this 5/5/25 order will have a bearing on this. So my submission before lordship today will be possibly subject to what your lordship says, my lord, that they let the earlier appeal be first disposed of. If it is disposed of by allowing the appeal, then part of this order will automatically go, because this order has been based on that order, thinking that same election has been put to challenge subsequently. Why should we interfere again? Because this will go against that order. So I submit to your lordship that let the judgment be passed in the earlier case first. This case may be deferred. Based on that judgment, this decision can be taken. This will have a direct bearing on the present case, which is before your lordship today. That is my case.
But the fact is,
My
you will be knowing better. I mean, while making absolute the ad interim injunction order, the same principles will lie. All the three golden principles.
Absolutely, my lord.
Prima facie and all this. By relying on judgment in some other case, they cannot do it.
My lord, some other judgment in some other case as a my lord, precedent or as a ratio in another case is one thing. But here is a case, same election result is put to challenge by some other candidates, students in a different case, and there is an order restraining the further enforcement of that result. Supposing, my lord, this court passes an order that no, I'm not granting any injunction. Even then, by virtue of the order passed on 5/5/25, the injunction would have continued.
No, what I have seen is 5/5 order is also passed basing on 110, the ad interim injunction passed in the first disappeal. See 5/5 order.
My lord.
Here also. Subject to correction, of course. This is in favor of so and so. Title suit has been registered in the same facts and instant case may be. See the page number 13. I mean, since the instant case and the title suit and the IA are having same facts and common.
My lord. Lordship is referring to which page, my lord?
No, 5. I'm referring to 5/5 order.
Yes, ma'am. Internal page, if your lordship kindly refers.
No, they have clubbed the matters together.
Yes.
But somewhere I find even 110. Yes, is already. Mr. Manoj, see page 13. Top
13. Yes.
On the other hand, third lines from the top. On the other hand, restraining the result notification dated may cause only temporary. Okay. Moreover, one similar case challenging the said result notification dated so and so is already pending before this court, which has been filed by 2 candidates who have been declared unopposed. And one ad interim injunction has already been passed by this court, by so and so, arising out of the so and so. So 5/5 order was also passed, basing its reliance on 110.
Yes, yes.
And then again, on 110, then 10/6 was also passed relying on 5/5. So it is like one after the other. So what I'm thinking is, of course, subject to what I'll pass 2 different orders in 2 applications. And I want an answer from you on another aspect. What about the letter that the Chief Election Commissioner wrote to the APSU saying that the election has been properly held? You have seen that letter? Where is that? That the Chief Election Commissioner's letter, where they have said election is properly held.
Page number 194.
Which one?
194.
In 05?
005. We are in 05.
194, yes.
194. Please see, Mr.
I would like to inform you that as per direction by so and so, to conduct the election of all so and so, we're going to successfully on so and so at following. Therefore, I am submitting you election result to so and so. Yes, my lord, this Chief Election Commissioner has passed the notification on 27 September, based on which the election was held and which is under challenge before your lordship. So he will naturally communicate in that way, my lord. He will naturally communicate in that way.
No, as far as the question that APSU has recognized,
My lord.
and secondly, the prima facie case, we'll have to see prima facie case now. We are not entering into the plaint. So
Absolutely, my
prima
lord.
facie, prima facie, it shows that it has been held.
No, my lord. My lord, that is what I'm saying. When we say that it was not held at all, and these allegations are denied in such a way that simply denial, and they do not say anything. My lord, I'll refer to the provisions of the Civil Procedure Code, which says that mere denial will not do. Lordship will kindly take the Civil Procedure Code, my lord.
What is the provision?
My lord, Order 6, my lord.
The first one. Order 6?
And Order 6, I'm coming.
Yes.
I'm
No,
sorry,
that
Order
we
6.
know, we have to
Lordship,
form of pleading.
yes.
They
My
have to
lord,
specifically deny.
you have to not only deny, but you have to state what is your case. Order 7, my lord. Order 7 is the written statement.
No pleading. Order 7.
Order 7, my lord.
Order 7 rule.
Order 7 rule. My lord,
11.
Yes, my lord. No, 11 is rejection, my lord. I'm sorry, Order 8. I'm absolutely sorry. Order 8 is the written statement.
Okay. Order 8.
8. Order 8 says, my lord.
Rule 1, written statement.
My lord, Order 8, Rule 3 says denial to be specific.
Yes.
Then 4 is important. Evasive denial, where a defendant denies an allegation of fact in the plaint, he must not do so evasively but answer the point of substance. Thus, if it is alleged that he received certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he has received that sum or any other part thereof, or else set out how much he received. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with the other circumstances. And then next paragraph. Even allegation of fact in the plaint, if not denied specifically or by necessary implication or stated to be not admitted in the pleading of the plaint, shall not be admitted except when circumstances. Well, what I'm saying is, my lord, mere denial will not do. You have to state what had happened on this that day. We say it was not held. You say, no, I'm denying it.
Paragraph 13.
My lord, paragraph 13, they are simply denying that our allegation that it was not held. But mere denial will not do. You have to say that how it was held, because it is an allegation of not holding the election, who was present holding the election, under whose supervision it was being held, who participated, who filed the nomination paper, who are the voters who were present there. Forget about the intending candidates. What about the voters? There is not a single averment that the voters were present to cast their votes. It is another thing that in the absence of any contesting candidate, the result of the candidates filing their nomination will be declared uncontested. It's another thing. But the voters must be there. It has to show that it's a free and fair election. Nothing has been shown about the holding of free and fair election. That is what my submission is, my lord.
Those are there.
My lord. Lordship will kindly see the hasty manner in which it was held. So let the trial continue, my lord. In the trial, it will be decided whether the election was actually held or not.
That trial, of course, should be done fast also because 3-year term period.
And so far as just one submission, my lord. So far as defendant number 6 and 13 are concerned, they have filed a written statement and they have specifically stated that election was not held. And they have not annexed the and now they have not annexed the copy of the written statement filed by them in this FAO.
That I don't find 6 and 13's written statement.
Yes. They have filed a written statement saying that the election was not held.
So it is here 3 to 6.
6 and 13.
6 and 13, madam.
Where the paragraph?
No, para 9 or she will find 9.
The answering deponent admits all the material allegations, but they wants to add that the defense 6 and 31 have never been asked and taken their prior consent before they have been nominated as vice president protocol and so said post. Okay, paragraph 9.
In fact, my lord, it is the case of the defendants that they were registered, but registration alone will not do. One has to submit a nomination paper for an election. That is what they have stated in their reply, my lord. I'm just showing once again. In their reply, they have said they were nominated. Page 161, line about third from bottom.
Yes. In the same paragraph 13.
Yes, madam.
Yes, I've seen this.
Yes.
This is.
Only defendants submitted their nomination papers. And they were only registered, but they never submitted their nomination papers. So that is the position, my lord. Nomination paper was not submitted. Why? They could have said that yes, you were present there, but you did not submit your nomination paper. The matter would have been different.
Until 2 p.m., no nomination papers were received from any rival contenders.
The situation was such that DC had to intervene. Situation was normal, not normal. This is the case of the plaintiff. Now, unless the defendant shows that it was an absolute normal election process and all were present, he chose not to contest the election, not to submit the nomination paper, then the matter is different. But here, all the overwhelming materials clearly show that it was done in a very hasty manner. It was done against the direction of the deputy commissioner, and the averments made by by both the parties clearly show that it was not a normal process of election.
And just tell me about 6 and 31 again. What is their case? Respondent, defendant number 6 and 31.
6 and 31, Lordship will find that para 9, they have stated that regarding the contents of paragraph 10 and 11 of the plaint, the unsigned defendant admits all the material allegations of the said paragraph, but they want to add that para 9, madam.
No, that I have seen, but in the plaint, they are respondent number 6 and 31.
My lord.
Defendant.
My lord. 6 and 31.
What is, they were also unopposed elected. And what happened? What they had not submitted nomination papers.
No. And that your lordship will find in
submitted nomination paper also, as well as, madam, I will say defendant also receiving the certificate of election photograph representation where he has written his signature, writing the letter to the absolute, don't accept any complaint from the plaintiff other side. So all things I have to close. That is there. So this is later on he took this part. Otherwise,
my lord, just one sentence, page 163. Page 163. Paragraph 14. This is a part of written statement, my lord. Paragraph 14, in the middle lordship will find there's a word although.
Although plaintiff number 2.
Although plaintiff 2 and defendant number 13 had not submitted nomination papers, they were declared elected. How can it be declared, my lord? It is the averment of the appellant before your lordship.
So they did not submit nominated. Okay,
nomination, and they were.
But
so
31 and 2. But what happened to 6?
Defendant number 6. My lord, defendant number 31 is here. It is defendant number 13.
6. Defendant number 6.
6, my lord, they have not possibly said anything in specifically. But 31, they themselves are saying that he has not submitted nomination paper. This shows that how the election was conducted.
Yes. And what about caveat, Mr. Majumdar?
Caveat, what is?
Without hearing the caveator,
My lord.
110 order was passed.
My lord, now they are challenging the final order, which is the 110 order has merged with the final order. So ultimately they were heard. Had they approached this on the court against an order passed on 110 on the ground that they had a caveat and then not hard, then the matter would have been different. Today, your lordship is hearing a case where the challenge is to an order which was passed by after hearing both the parties. So that point possibly doesn't have any relevance today.
Achha.
Yes, ma'am.
Okay.
That is my submission, my lord. Will pass the appropriate law.
Okay. Okay, Mr. Mohan.
Ma'am.
Yes.
Some clarity.
Mm-hmm.
My lord, so far regarding.
Reply. Yes. Then.
First thing is, my lord, those subsequent issues can be raised only first what the plaintiff had to show what is their right infringement, what rights they have. Now the case is there. Now they have admitted. They filed nomination. They have not disputed. But so far, plaintiff number 2 is concerned. We said that he did not file nomination. Plaintiff number 2. Plaintiff number 1 filed nomination. But plaintiff number 2 had enrolled himself in the enrollment list. So there is a requirement of getting if somebody wants to contest, one has to get enrolled in the enrollment list as per the bylaw. He enrolled himself, plaintiff number 2. Plaintiff number 1, he filed nomination. This is nomination. They have not disputed. Now, once we have filed nomination, and enrollment is there since nobody was coming. That's why even we declared event we declared because we wanted to fill up that. Because he expressed in this. This is the fact. So here, how their rights are. Is it the case they have been prevented from filing nomination? No, not filing. Now, what right is filing? First question. Now, they are not for the other posts. They are only for these 2 posts. And they only in the case if they are not allowed to file nomination, then they may have a case. But here is not the case. Then they have not been allowed to.
But anyhow, things were in a very hush-hush manner.
My lord, it's not in that manner. Now, my lord, another point, my lord. Now, so far, defendant number 6. Now, plaintiff has to stay in its own field. Now, if you say you don't have you cannot make out the case, then you will later get some defendant you will manage and get admission from there. You cannot prove your case from their defendant. Now, my lord, kindly turn to my reply to the rejoinder in page number starts from page 344. About defendant 6, I have brought on record about his participation.
344.
340.
Yes. This is a photograph.
Photograph. He is the defendant number receiving his election. Well, that he has elected the vice president protocol. He is receiving the.
This is oath taking.
After oath taking, because on oath taking he was in his house. For some urgency he went to the village, so he could not remain. So later on he came back. Then this certificate of election was given to him.
So defendant number 6.
Yes, my lord. Now, my lord, kindly turn to next 346 page number.
Yes.
346 page. This is the nomination paper of the defendant number 6, my lord.
Defendant number 6. This is the nomination.
Nomination.
6 has filed nomination.
Nomination file, madam.
Only 36 has not.
36 has
32 or what?
Only plaintiff number 2 only.
Only plaintiff number 2.
2. But he got himself enrolled.
Because he got him. That is your submission.
Yes. Now this is his nomination paper. Now we got his signature. Then he should have filed the FIR against us. Nobody has put his signature. He has put his signature.
This is for the trial court to see actually.
Now, because now they are saying that we did not. That's why I'm saying that they were allowed to file the nomination. This goes with. Now, my lord, kindly turn to next page, 347 to 350. This is the representation submitted by the elected candidate to the APSU, saying, don't entertain any complaint from the plaintiffs in title suit number 7. That Chera Chachu. So here also defendant number 6 has endorsed his signature. Is a part of the representation saying that election was properly held. Everything was properly done. Therefore, this unnecessary allegation complaints should not be entertained from the other part.
Here, these defendant number
6.
was also here.
Yes, my lord. So now later on, my lord, people can be managed, my lord. There can be so many reasons, and my lord will know. Defendant number has been now appointed as a president of some other organization.
And that you have said.
No, my lord, that is in the plaintiff number 1. Now, defendant number 6 has been also appointed as a president.
Acha,
Maybe some, my lord, for showing that loyalty or something, how they have been.
to some other union.
Yes, to other union as a president. Now this clearly, now my lord, only first, my lord. Now another point, my lord, as my lord has rightly said, that so far Deputy Commissioner notification is concerned, that is that in respect of the notification issued on 25, not to hold the election. But there is no subsequent notification whereby the notification issued by the Chief Election Commission on 27 has been prohibited. That has
No, show me why the date was changed from 27, 28 to 28, 29. There's something in between.
No, my lord, because 25 notification has been prohibited. Now, subsequently, after getting permission, my lord, I have to issue fresh notification, which I did on 27. Then I prescribed the date that it should be on 28 and 29. Because that, my lord, there is no my lord, that power.
Where is the Chief Elections Commissioner's notification fixing it on 28, 29?
My lord, that is here, my lord.
It's 74, I think.
74.
My lord.
No, not that one. Not 74.
74.
Chief Election on this so and so. So he fixed it on 28, 29. I think this is the one.
My lord.
And where is that Chief Commissioner's notification on 25/9? 25/9. I think
Page
69.
page 70, my lord. Yes, page 69 and 70. Typed copy, page 70.
So this notification was actually set aside by the DC, but not the notification that you have pointed out at page 74.
Now, in this, my lord, I'd like to conclude my lord. My lord, this all issue first, how they are affected. It's not something they have been deprived. They have been exercised all this. And if they don't want this post, this post will be definitely re-election will have.
Yes, that you have said.
All this post. So if they don't want to hold this post, including the post of defendant number 6, because as of today, nobody is holding post. Definitely re-election will have. Now, with regard to other candidates, those who are the applicants before my lord, for them, there is no content. So for this case, these two plaintiffs are not the contender for the post which we are holding.
Acha, plaintiff number 1 and plaintiff number 2, you said there is a bar on plaintiff number 2 for 6 years.
That bar, my lord, we have not created in this case. That bar in the other case.
That other case only I am speaking of.
Here, no bar.
Here, they were elected.
They have been selected. They have been declared elected, my lord. Now I cannot say there is bar. So now only they are saying that for the best, what's for the reason they are saying that even they are not denying that nomination was not filed. What their plaintiff is saying is that no voting took place. Only that. But when there was no any rival candidate, this is our name. Now, as in today, they are also our part. But my lord, it is not something, my lord, that the person who is holding their post and they have been deprived, they are challenging. What the post they wanted, they intended, they have been selected. Question of infringement as well. And what the post appellant are holding is not the post which they wanted to contest. So therefore, my lord, how they can raise the issue on the post which they never intended to contest even. So these two posts, it's up to them, my lord, whether they want to. Still, nothing happened. No rights has been infringed. So, my lord, it is not something that they can take up like in the PL form, this civil. The plain
No,
cannot
as far
file
as
civil.
this petition is concerned, where Mr. Majumdar is there,
With this, my lord,
that okay,
my lord,
they were elected. But what about the other one?
other one, my lord, I have said, first plaintiff number 1, 2, both are, there is a my lord disqualification.
And that you have shown from the
Yes,
constitution.
and my lord, there is plaintiff number 1, already 6 years ban from the.
Plaintiff number one,
My lord.
6 years ban. And what about,
is a politically affiliated candidate.
yes, that you have shown.
I have shown, my lord.
And what about plaintiff two?
Plaintiff number 2, that's, there is he also doesn't meet the qualification.
Oh, that also is, other than that?
Other than that, my lord, he did not find the
Nomination.
He did not enroll himself in the enrollment.
Neither nomination.
Yes. And my lord, last submission. Now it is very interesting. There, this is a contradictory statement in the two plaintiffs. Why? This so far, these plaintiffs are concerned with the responsibility. Now they are saying, so far filing of nomination is concerned, defendant number 6, defendant number 31, this plaintiff, all these things are filing of nomination by them not in dispute. They could file the nomination. Meaning thereby, there was no police guardian. Otherwise, why this court could have filed nomination? This fact is clear that they have filed nomination, meaning thereby this was not guardian. Now the plaintiff in other petition, what is saying that we
Defendant 31 is also elected unopposed.
yes, all of them.
6 or 2 also.
6 also, yes, 2 also. Now that's why, my lord, why their statement is incorrect, I am saying. So, these defendant, those who are now in support of them, they could file nomination. Now, right now, they are supporting the plaintiff in this other case. Now, this is not their case that they could not file nomination. Now, what the other case is saying, plaintiff, in other case, no, there was guarded by the police. There's no question of filing any nomination. How this 4 person, 3 person could file nomination, those who are his party now, and how another person could got himself enrolled in the enrollment list, and what prevented them from getting enrollment list? How this can be? There was no 2 venue. The same facility given to them. Is it something they came, we did not allow, or we pushed him back? Where is the statement?
Yes, okay. Those things.
I only saying that this factually, even these are contradictory statements. With this, madam.
Okay. Okay, Mr. Majumdar.
Correct. Just 1 minute. I will not take more than one. Just
Yes.
one reply, ma'am.
Yes, yes.
As your lordship has
take-
asked, just a couple of minutes. As your lordship has asked, and my learned friend is saying, they were also elected. Why they are unnecessarily fighting and litigating? My lord, page 50, para 15 of the plaint.
Page
The
15?
plaintiff saying,
Page
50, my lord, 50. Page 50, para 15.
In your petition? Yes.
My lord,
Yes.
in my case, my lord. Para
Page
15,
yes.
it is stated that the plaintiff, yes, page 50, para 15, that the plaintiff begs to state that they could have happily accepted the post they were declared unopposed in the impugned declaration of result. However, they have a distance to go in the student politics, and they want to be they want a change in the student politics system, and for that sincere effort, this is the first step to discourage such peculiar and illegal practices having been adopted in the present days. So it is not a case of assembly election or MP that you were elected by your. It is a student politics. They want a free and fair election, which was according to them not held. And secondly, my lord, regarding the 2 controversial letters of the same day of 27 September, just one sentence I want to show from the written statement, page 160. Page 160, madam. What is their stand regarding the one which said stop? One is to go and the other one stop. So what is their reply? This is very important, madam. Page 160, in the middle, lordship will find there is a date 28/9/2024. Page 160, my lord.
Yes,
Lordship is-
28/9/2024. Yes.
Just below that, regarding the word regarding.
Yes, regarding another.
Another purported order dated 27/9/2024 issued by the DC Colorian, the answering deponent has no knowledge of the same and doubts its authenticity. So they are also accepting that there is an order, but this is somehow not telling with this case projected by them.
Yes, okay.
That is all, my lord. Now Lordship will decide. I'm very grateful to your Lordship that your Lordship has given so much of time in spite
No,
of.
in fact, I did not give time to him.
My judgment yesterday's
Yes,
judgment.
two judgments. Yes.
These two judgment, one is from our own High Court.
On what?
This on the issue when this prospective petitioner's name was not there.
Oh, caveat one.
Yes, caveat one. Then it says that still this has to hearing has to be. So
Notice has to be given.
notice has to be there, even though prospective name must be highlighted here.
Which one? Both?
Our own High Court bylaw just 1995 GLR and Madras High Court 2009 also. And this 1995 GLR, it has relied on the judgment yesterday I have placed even
Yes.
that without jurisdiction.
This is paragraph 12.
My lord, yes, 3 and 12, my lord. 3 is the facts is given, so that we understand on what basis this 12 this has been held illegal. Facts and
3 and 12.
Yes.
Then the other one?
And other one, my lord, there are this my lord, I have written on the top, my lord.
Yes, paragraph 18.
18, my lord. The third person event, it has to be given. So, my lord, in my case, my lord, why otherwise, my lord, this ABL matter may not be in the appeal. My lord is here considering the case entirety in the merit. My case, my lord, is same. Versus ad inconvenience. While making absolute also, I was not heard. And my written.
So absolute you were heard or not heard?
Not in this case.
5 you have heard. Yes.
Yes, in this case, and my lord, I even because oral argument chance given that was denied, even that could not happen that much we should have my all these contents in way discussed, whatever I raised in my writings.
Okay.
With this, my lord, much more.
This 10-6-20, my lord, 10-6-2025 order was passed after hearing both the parties.
No, there was a prayer made by the junior for adjournment, but then again the trial court judge said that later the junior said you can pass whatever you want. That is reflected in the order.
My lord, he said prayer for adjournment of the case. Further, he submitted that the court may pass any order as the wisdom of the court. So he gave the court to pass the order.
That is what is reflected. But then again, in the first instance, he prayed for time.
He prayed for time. It is for your lordship to decide whether lordship will grant time or not. We always pray when always your lordship do not allow.
Yes,
That doesn't mean that the order is bad on that ground.
Yes. Okay. Hearing
Deeply obliged, ma'am. Deeply obliged.
Yes. Hearing
Lordship, Lordship,
judgment result.
not new one. That page 163 may be kindly taken note of.
Second.
Which my senior
Second application.
Page 163, wherein they have themselves admitted that although plaintiff number 2 and defendant number 30.
163.
Page 163.
Our lordship has taken note of that. All right, lordship may.
163, page 14.
Which one?
I have only referred minute, page 161.
No, I think in his petition, he is saying.
No. In this same petition.
Same.
163, wherein they have themselves admitted that nomination for plaintiff number 2 and 31, it was not found.
Okay, but then they said that they were enrolled themselves, so then it is allowed. But yes.
All right, lordship will pass the order. You should not detain your lordship.
I'll not delay in passing orders because I'll forget. I don't like keeping it parted for long.
As your lordship
then perhaps I'll pass it tomorrow. The order.
Deeply obliged. Deeply obliged.
Hearing concluded, judgment reserved. No, I'm not getting it. Oh, yes, he said something. But then bail hearing, otherwise again. After bail hearing, I'll finish bail hearing soon. These will all.
From 3 to 6.
Oh yes, you are for responding. Oh, okay. Keep this properly so that. Vanessa, these will all go to the chamber. Then these are all Yes.
Yes.
Item number
11. Your Lordship, on last occasion, CD was called for along with GR entry.
Item 11.
Item 11.
Achha. CD was called for.
CD was called for.
There is no PP today.
He was there.
Yes, it is. Yes. This is for. The case there is there.
Yes, my lord.
Your Lordship, my prayer would be different, Your Lordship. This, the accused, this offense, there is alleged against the accused person is intermediate. The punishment is maximum up to 10 years. So, Your Lordship, and the detention, the maximum judicial detention is 60 days. So far,
Maximum detention what?
judicial detention is 60 days. So far, he has spent 57 days, Your Lordship.
So default, another 3 days to go. Let him get instruction whether they'll file charge sheet.
Now, Your Lordship, within 3 days, Your Lordship, it is not likely that the police will file a charge sheet because, Your Lordship, next week, after tomorrow, the session court is also going for a holiday for 1 week.
Because,
At the same time,
because see, if I interpret 60 days as 56 days, how can that be? I mean, there are so many cases I see, even 50 days, they say, okay, another 10 days, but they might come up with the charge sheet within these 2-3 days. Otherwise, you're not entitled for default bail.
Because if we see the accused person has already given his statement, there is nothing, Your Lordship. The purpose of arrest and detention has already been achieved.
What do you say, Mr.?
Yes, my lord, there initially on last part, they come with a ground of arrest, on ground of arrest. That also goes because it has been communicated. So now, Your Lordship, so far as my brother is submitting the default bail part, it's premature right now. And so far as Your Lordship, the submission on, since his statement has been recorded and all, that cannot be a ground for granting bail, my lord. It is very clear, bail law is very clear. So now it's since they are already in custody for 57 days, the 3 days is still remaining. The investigation as an authority, they have they still have the 3 days time to file the charge sheet. If it is filed well within the time, then there is no question of, Your Lordship, default will come. And it is
How can I give you default bail if they come up with the charge sheet within these 2 days? What is the last stipulation in the charge sheet?
Your Lordship, actually, Your Lordship.
Or in the case diary?
Yes, on case diary, my lord, regarding the dates and all, it was there, Your Lordship, on whether on the particular day the person were arrested or not, that has been clarified through the case diary, Your Lordship. It was on the same, on 7th itself, Your Lordship. They were intercepted, they were arrested, seizure made, and then, Your Lordship, the FIR has been registered, Your Lordship. That is what usually done in the NDPS case. The procedure is, Your Lordship, when information received, they have to communicate it to the higher authority, and then they make NACA and all. And then when they intercept, Your Lordship, they arrest and make seizures, and then, Your Lordship, since they have committed the offense, so after commission, they record the FIR. Because on anticipation, Your Lordship, FIR cannot be registered. So in NDPS case, prior registration of FIR is not mandatory. So that part is complied with. And so far as section 50 is concerned, my lord, it's clearly there in the record, Your Lordship, that has been given. In fact, section 50, some dilution has been made by the legislature that you have to, the concerned person has to inform his right that whether his personal has to be conducted before the magistrate or not. That part was also done. Additionally, my lord, the magistrate was also there. So that part also goes. And so far as section 52 is concerned, compliance, my lord, Your Lordship, while the
52 is those
42, my lord, that during
42.
Yes, 42 part is, my lord, very clear. So the Supreme Court also, Your Lordship, earlier also I have given on the possession part, and in the later part, Your Lordship, it has been discussed that regarding that part, that all the issue has to be raised during the trial, not on during the bail on the stage of bail. And here also, Your Lordship, the information has been provided to the higher authority that complies also, my lord. So now nothing is there, Your Lordship.
What you want to say, marriage-wise, he has a very weak procedures were all followed.
Yes, all followed, my lord.
Your Lordship, on last occasion, the question was that the CD was called for to ascertain the date of arrest. Because, Your Lordship, as per the record, Your Lordship may kindly peruse the record. trial court record.
Okay,
The
why?
R-
A day of arrest is something
Different.
different. Show me the FIR.
FIR,
Oh, this one, page.
yes, Your Lordship.
Make sure that-
FIR, as per the FIR, the accused were arrested on 7/5.
Hmm.
Let's see, if we go
Yes,
to,
The 7/5 he was arrested.
Yes.
yes,
Yes,
7/5,
okay.
if you go to accused Chalan, he has been arrested
That,
on 8.
my lord, that has been corrected to GD entry. GD on GD entry, absolutely correct. It was 20 hours. So that is 8 o'clock.
And you know,
But your lordship, inadvertently, they have mentioned 0800. And that has been clarified here in the your lordship. You can find it the your lordship CD entry also, your lordship. And even your lordship, assuming you're not admitting, even if that is taken into consideration, whether that can be a ground for granting bail, that is the issue.
You mean to say the time of arrest is 8 hours? It means
Yes, 8
morning 8 hours.
yes, Your Lordship.
And whereas in the FIR it is said 19-13 hours.
19.
So that will not.
And Your Lordship, in 19, the information, secret information was received on 1913. And the
Ah.
seizure was made within 5 minutes. Your Lordship, come to the seizure memo of.
That can be done.
Again, whether that can be a ground for.
Your Lordship, I'm not taking this ground for a bail. My humble prayer is that, Your Lordship, the accused person I have confirmed with the family. He is the only son in the family. And right now, because of his detention, Your Lordship, his mother is a medical patient. And because of his detention, please deprive, Your Lordship, they don't have.
And those personal, those issues, why don't you wait and after vacation, if the charge sheet is not filed, you get default bail. Otherwise, merit wise, I've seen that there is no case.
Your Lordship, if the accused person is arrested, Your Lordship.
Achha, let me see the FIR. If I see that he is not that involved, okay. With due regards, sir, verbal information was received. Drug peddler is in possession of suspected selling off to the addicted youths in so and so the source. It is not source public stated. It was writing and entered into GD entry 42 is otherwise. After that, SP was conveyed. They gave verbal approval. Authority thing is also there. Also intimated written message. There is every possibility and temper with the evidence. So they immediately approached and without obtaining search warrant, the team. Okay, the team headed by the team apprehended. What is your name?
Said Farid, madam. From his possession recovered contract.
Acha, Sariful Islam, they apprehended one Sariful Islam. Served notice upon search, so and so, so and so, so and so. Sir, more peddlers are coming. The same was intimated. And left for Iman along with apprehended by the team intercepted Iman but both flee on the. Oh, I've read that time. The team apprehended them then. They have been identified Shaikh Farid. On search 2 plastic pouches containing so and so. From the possession of. So from your possession, 2 plastic pouches containing heroin of 13.3 grams.
And 11.4.
And 11.4 grams marked as so and so contained in 2 separate brown colored soap. They recovered from the possession. They of them coming to the I've seen the FIR. Things have been, of course, intermediate quantity was recovered from you. Procedures are followed. Your mother is.
Accused is always considered innocent. Your Lordship, considering the
But then see, these drug peddlers are destroying the society. Want to give. Don't think so. Wait for some days. If they do not file charge sheet, then.
Your Lordship, his mother is already undergoing a medical treatment. Therefore, Your Lordship, to support him to her financially, Also, if the accused person is detained,
There are no grounds for bail. I don't find any grounds for bail here.
any condition, in any condition.
He tried to flee, he was apprehended.
No, your lordship, with any condition.
That is written in the FIR. And they are selling to the addicts. Destroys the entire family. No bail, you wait till the charge sheet is filed. You either want to keep it pending or I'll dispose it of today. You again file a bail application later. Okay?
Lordship, kindly, my application may be considered because your lordship.
Here,
Deprive the accused person.
Huh?
It will, at the same time, it will deprive the medical care.
No, had it been some other murder cases also, I can release. But these drug addicts, they sell drugs to the addicts. Heard Mr. So-and-so? For the petitioner? And Mr. T. This is an application under section 483 of the BNSS filed by the petitioner for grant of bail in connection with Naharlagun Police Station case number 62 of 2025 under section 21B/29 of the NDPS Act 1985. The fact of the present case is that on a secret information, on a reliable information that a drug peddler is in possession of suspected contrabands and are selling them to the addicted youths, the police personnel, after entering the contents in the general diary, proceeded to the place where it was informed. Now, proceeded to the concerned place. After informing the senior officer and the team apprehended one Sariful Islam, from whom contrabands were recovered, and on interrogation of said Sariful Islam, it was found out that there were more peddlers who were coming to the said place for selling drugs. No, who were coming to another place in Naharlagun, who were coming to another place at Naharlagun for selling drugs. The police, as such, left for the said place and intercepted 2 drug peddlers who, however, attempted to flee, but the police personnel somehow apprehended them. The police apprehended them. It is the petitioner who was apprehended. There the police, and on search being made, contrabands were recovered from him. Which weighed 13.3 grams and 11.4 grams of heroin, including the plastic pouches. Thereafter, from his pocket, it was recovered from his pocket. Thereafter, the police personnel arrested the petitioner with the others and lodged the ejahat and registered the case under section 21, subsection B/29 of the NDPS Act. The counsel appearing for the petitioner submitted that the amount of the contraband recovered from the petitioner was intermediate in quantity, and that the date of arrest, the time of arrest was shown differently in his arrest memo and in the first information report. He also submits that the petitioner has an ailing mother who has to be looked after. Mr. T. Ete, the learned public prosecutor, however, submits that all the procedures required to be followed under the NDPS Act were adhered to, ADHERED were adhered to by the police personnel, and there was no violation of any of the provisions mentioned in the NDPS Act of 1985. Further, he submits that he was caught red-handed with the contrabands in his pocket. He also submits that the difference in the timing of arrest in the arrest memo and the FIR will not have any consequences in the case. Heard the counsels, perused the records, perused the case diary. What about the submissions, the 161 statements, police personnel?
Yes, 161 statement, Your Lordship, he has admitted, Your Lordship, the accused person. Because, Your Lordship, for the purpose of bail, Your Lordship, no doubt, Your Lordship, you do not have the substantial piece of evidence. However, for the purpose of investigation, Your Lordship, the prima facie satisfaction has to be seen from the record and the material whichever has been collected, and even the 161 statement. No doubt from the co-accused statement is so tenuous. However, Your Lordship, he himself has admitted that he came with this pouch and he is a drug peddler as well as he is a addict also.
In his 161?
Yes, my lord. 180 statement. And my lord, the second part would be, my lord, the ground of arrest was also communicated so that in future again they should not come.
No, yes. It is noticed from the case diary that the police has recorded the statements of the witnesses along with the statement of the petitioner. None of the witnesses have stated that the petitioner was not involved in the offense or that the contrabands were not recovered from his pocket. The petitioner himself has also admitted in his 161 statements before the police that he is involved in selling contrabands . And another thing, you see, in his submission, the learned counsellors have submitted that the petitioner has been inside for 57 days in jail, and since the mandatory period is 60 days, he may be released on bail. Last में लिख लेना वो. Yeah, okay. In the FIR, it is writ large that the petitioner tried to flee when the police went to the place where they were trying to sell the. He tried to flee when the police reached the place on the information given by the co-accused, Mr. Sariful Hussain. Therefore, in the facts of the aforesaid case, this court is constrained to is constrained to not to release the petitioner on bail, the bail petition is as such rejected.
I know the ground of
Petition.
ground of
Ah.
arrest was also communicated.
And books ऊपर में लिख दो, just right, the mandatory grounds of arrest under Article 22(1) of the Constitution of India as well as under Section 50,
Yes.
no 48, 46.
48 and 40, 50, man. 50.
No.
Ground of arrest, your lordship.
50 is CRPC.
50, your lordship, yes. NDP, as per the NDPS, my lord.
NDPS is what?
Yes, your lordship. It's
I'm bringing CRPC.
52, my lord. Disposal of person arrested in Article C, your ground of arrest is there. 52.
Was complied with. What did I say? The mandatory grounds of arrest as required under Article 22(1) and 50.
52, my lord. 52.
52.
52.
52 of the NDPS Act has also been served upon the petitioner.
Obliged.
My please, Lordship. This is the matter which has been adjourned by the victim counsel without my consent.
Oh,
So
yes.
as I mentioned, and the matter has been taken up. So as per directions of your ladyship, I instantly went and informed him about the taking up of the matter. And then after accordingly, I have informed to the land PP regarding the information that I have given. So here in this case, my lord,
Where is he now? Your
now
lordship,
he is
he
not
seems to
appearing.
have already left the court, your lordship. Otherwise, your lordship, since this is a POCSO matter, your lordship, and they've made their appearance. If the
In their
parties-
absence, so I cannot. Because every stage,
But
victim
my lord,
has
this
to
is
be heard.
my lord, may I kindly consider that this is the deliberate conduct of the council from the part of.
Actually, the bar will look into, but then I cannot hear you.
This is
in
my
absence
case,
of-
my bail application, and then without informing me, he's but taking an adjournment, and despite that, as per the direction of your ladyship, I have informed him.
I'll
that-
fix it. I'll fix it immediately after the holidays. So if
look,
he does not come on that day, a legal aid council will be appointed.
Otherwise, the ladyship, after receipt of the TCR record, it's including today's listing, it's been 4 times. On the last occasion, on last 3 occasions, matter couldn't be reached due to time POCT, and today, though it is reached, but then deliberately due to the conduct of the victim council. Now, again, I have to, whereas here in the case, I have only,
This next date, if he does not appear, then a legal aid council will be appointed.
otherwise, your ladyship has already heard part on the last occasion. It was represented by J. Siring, wherein here in the issue is only with regard to non-mentioning of the ground of arrest.
But then without the
Then,
presence of.
can it be ladyship?
Go against the Supreme Court order. How can I?
Can it be, then in that case, ladyship, can it be on tomorrow?
Tomorrow not possible. Tomorrow not possible. It will be either during the vacation, before the vacation bench, that you do it with the registry, or I'll fix it. Today you take time, try or before the vacation bench.
Otherwise, then in case, Lordship, I am bound, I may be allowed to withdraw with the liberty. Because the High Court is proceeding on the vacation, but the subordinate court, trial court,
Before the.
yeah, I want to go back on the trial court for the press file
Try
application.
Try there.
Since another 20 days, something is there. So may I humbly pray that I may be allowed to withdraw with the liberty on the same ground to approach before the trial court.
As prayed for by the petition, by the council appearing for the petitioner. No, the council appearing for the petitioner has prayed that he may be allowed to withdraw the instant petition with the liberty to file a fresh application before the appropriate court of law.
On the same ground.
On
The ground which I.
whatever ground set, the prayer is allowed, petition is disposed of as withdrawn.
Much obliged.
Marvelous work. So, my lord, after passing the order in the item number 11, as if it seemed nothing left. But since, my lord, why I'm saying so, my lord, this is out of the same PS case. But I have a different footing, my lord.
Oh, this is Sariful or what?
Yes, no, this is
Negotiable. Same FIR.
Ashraful, out of the same FIR.
Oh,
But it has a different path. So,
From
so
him, so much of contraband was recovered.
no, nothing has been rebuilt.
From you?
No, nothing has been seized from me.
Hmm.
So, so far the last argument is concerned that it has come to this position that nothing has been recovered from me.
Let
Or-
me see, you are what? You
Asraful.
Asraful. Asraf.
So, two so and so came from the Lakhimpur, so total amount. From Ashraful, nothing is recovered.
Yes, nothing has been recovered.
He was with Said.
Side for it, my lord.
If Said Farid, he was with an Ashraful.
Yes, and
They are
the
separate.
side frame, this the in item number 11 was the pylon rider at that same time. And what my submission was that I was not aware of the facts whether he had carried that or not. Now, my lord, before come to that, my lord, though now this matter was adjourned only on the ground that on the particular day after hearing to the certain extent of the hearing, it was adjourned on the ground that the CD was not fulfilled, and the CD supposed that CD in respect of Asraful was not
Acha, acha.
Side
So
for it.
that is there before.
Sure.
Yes, yes.
Yes, my lord, here, your lordship, here in this case, your lordship, on last day, my lord, actually, his CD was received, but that for his side for it, CD was not received. So in his case, your lordship, the ground of arrest was already communicated. He is not come on that. So now here the issue here is, my lord, here in this present case, section 21V is there for the intermediate quantity. Now section 29,
Nothing is recovered.
my lord, section 29 cannot be ignored. That is the conspiracy part, my lord. So now it can be revealed from the case diary, your lordship, whether his involvement was there or not. Because your lordship, merely because he do not have the possession, it cannot be said that he is not involved, my lord. If there is a material to show that he was involved in the commission of the offense, then he will equally liable, my lord. The section 29 is there, my lord. That cannot be ignored, my lord. So your lordship, the statement, your lordship may kindly peruse his statement, then I will rely on judgment, my lord. Two judgments. Earlier also I relied.
There is nothing to show that something
Yes,
is
from
recovered.
his body, in person, nothing has been recovered from him. But his statement and your lordship, the statement given by the co-accused clearly shows that he was involved with them. Yeah. The section 29, my lord, also we cannot ignore.
Give me NDPS. $29 is abatement or something, right?
Yes, my lord. Section 29. Punishment for abatement and criminal conspiracy, my lord.
No, wait. 20. Yes.
Whoever abates or is a party to a criminal conspiracy to commit an offense punishable under this chapter shall, whether such offense be or be not committed in consequences of such abatement or in pursuant of such criminal conspiracy and notwithstanding anything contained in section 116 of the Indian Penal Code, be punishable with the punishment provided for the offense. A person abates or is a party to a criminal conspiracy to commit an offense within the meaning of this section who is Indian abates or is a party to the criminal conspiracy to the commission of any act in a place without and beyond the India would constitute the offense if commit within India or under the law of such place is an offense relating to narcotic drug or psychotropic substance having all legal condition requiring to constitute it such as an offense the same as analogous to the legal condition required to constitute it an offense punishable under the chapter if commit within. Now here, your lordship, his role is he was sent by the Said Parid.
He was?
Sent by the Said the accused, let me reject that, my lord. He sent him to get the customer who purchased the contraband substance. And for that, he also get commission out of it. So for that, he came here to Itana or Naharlagan and he made the customer unknown person. The name has not been revealed by him. And then he informed the Said Parid. And then when Said Parid came with the contraband substance, he was in his purse, he was intercepted by his motorcycle.
Both of them were together in the motorcycle.
Not, my lord, not together, your lordship. Actually, on that day, your lordship, that fact was not clear. That is the reason CD was called for. So he was first intercepted by the police, and then the police had waited for the Said Parid. Then Said Parid came with the contraband substance, which your lordship already has seen, your lordship.
Where
So
did you get those facts?
Here, see, case diary, my lord.
Who stated?
Your lordship, the Said Parid as well as he himself.
He's okay, Shahid Farid, and nobody else.
Yes, my lord. Nobody. And your lordship, this witness also, your lordship. The who lost the
Person.
yes, informant, your lordship.
What did he say?
Your lordship, this is
What did the informant say?
informant.
Give me that informant statement.
Yes, your lordship. This is the informant statement.
It's in English.
Yeah, it's in English, madam. Informant, your lordship, is the police itself, your lordship.
If he says that something that he was waiting for he had the client and then I will see the source for him. He said police team then left for so-and-so along with apprehended person Sariful. The team intercepted 2 drug peddlers.
Yes.
But both of them returned. It's almost like the FIR.
Yes, your lordship.
Both of them attempted to flee from the spot on motorbike. The team apprehended them. See, as if they both were together, it seems. They have been identified as so-and-so and Asraful. They were served with notice and so-and-so. And it was released. I don't think so.
My lord,
The
accused and co-accused statement, my lord. Regarding your lordship, granting is, I leave with your lordship discussion.
statements are very less important.
Yes, yes, but your lordship, if it cannot be read in isolation, no doubt, your lordship. That the court can't wholly trust on the statement of the co-accused person. But your lordship, if the accused himself has stated, no doubt it cannot be held to be a confessional statement. But your lordship, at this stage of bail, my lord, because your lordship, the other thing cannot be gathered at this point of time because it's an investigation stage, madam.
Had the police said that yes, I have first apprehended Ashraful, he was actually searching for clients, and then we waited and the Shahid came. Not in the evidence. He did not say, as if 2 of them were intercepted together and they were fleeing.
And my lord, if an information has been received from the reliable source, how your lordship, without recording his statement, if person is apprehended on that particular place, how your lordship, the informant will know that that person has been sent by him or him, your lordship. There is an information received from the reliable source that the persons are coming for selling this contraband substance. He will definitely, he won't know whether what is there in their mind, that what he has done, he has not done, and for what purpose he came. He came there. Only after your lordship arresting and make proper interrogation only, the things will come up, my lord. Because your lordship is well aware that even the FIR cannot be an encyclopedia of entire fact. And here also, your lordship, the informant, although is a police personnel, he cannot, your lordship, narrate the every, and otherwise it will be, your lordship, otherwise police this person can be presumed to be doing a conspiracy with the accused person, my lord. If you know everything, man, definitely some grey part will be there, man. But the material.
As far as this is concerned, I'll give bail with severe conditions. Okay? He has
Yes,
to appear. Acha, this is a BA. He is arrested since? He has been inside?
Inside for last
7 days.
yes, last 57 days.
57 days.
Yes.
I will only refer one judgment, although it's a persuasive value, my lord, from the Kerala High Court, my lord. Because section on 29, your lordship, I will go directly to para 50.
Trial court to see, not at the stage of bail.
Yes, your lordship, at this stage also, my lord, this regarding the granting of bail, my lord. Para 15, my lord. In the instant case, there is no dispute.
This is a bail application.
Your lordship.
482.
Yes, 482, my lord.
No, this is 482 of CRPC. This is criminal petition.
Yes, my lord. But your lordship, the criminal petition is perhaps for the quashing or for granting of the bail, but not for the challenging the trial, man. Here, your lordship.
Which paragraph?
15, my lord. Your lordship, actually, it's for para 9, your lordship. First, the fact will clear from para 9, your lordship.
It's okay.
An application, 430 application was moved, my lord. That I will just point out. An application under section 430 of Code of Code for granting anticipatory bail by person who is accused of an offence under Act involving commercial quantity is not barred under any of the provision under the Act, but the restriction provided in section so and so is granting of the person of the accused.
This is commercial quantity.
This is not, I am not on that, my lord. This anticipatory bail is maintainability of the anticipatory bail has been discussed here. Now, your lordship may kindly come to 15, your lordship. Whether this aspect can be considered in the bail or not. In the instant case, there is no dispute raised with regard to the fact that the quantity of the MDMA seized from the possession of the parts accused amount to commercial quantity. The fact that no substance was seized from the possession of the respondents is immaterial. In the first place, in order to attract 22C of the Act, it is not always necessary that the contraband substance was in the actual possession of the accused. Manufacture, sale, purchase, import, export, and use of psychotropic substance without authority would also attract the offence. In the second place, commission of the offence under section 29 of the Act involving abatement and conspiracy is also alleged in this case, your lordship. The 29 has been taken into consideration because here also, your lordship, possession was not recovered, but still court take into consideration of section 29.
I'll mention.
Yes, yes, your lordship.
Heard Mr. So-and-so.
My lord, I am to answer, my lord.
Chopok Modi.
My lord.
Huh?
So, my lord, I am to answer 2 or 3 lines here. Yes, sir.
Acha, you want to play something?
Yes.
Hmm.
Because my lord, so far, one of my submission, respectful submission is, I am here before the bail court, under porter,
Okay.
under the
take-
discretion of
And
foreign.
your ground will be like nothing was
Nothing was, sir.
was seized from him,
Yes,
and then for that reason you want to.
exactly. And what I am trying to sum up, added is that even if it is assumed that, in my case, it is purely I am not involved. But despite of that also, even if it is assumed that I was involved in that part also, can my lord, the provision of this court, discretion of this court, can be, my lord, cease? I say, my lord, I answer myself as, my lord, no. Because the discretion power of this court is still there to consider the bail. And I admire the submission on behalf of the state is fully explained. But to this extent, this submission should be in the trial stage. I am here in the bail stage. Therefore,
Okay, I'll
I am
consider
trying-
this. I'm considering your application. Heard Mr. I'm considering it. Heard Mr. So-and-so. And Tiete. This application has been filed. You say something. I'll this one. It is same as
Yes,
CA.
FIR, the verbatim of the FIR only.
Where this is an application filed by the petitioner. Filed by the petitioner under section 483 of the BNSS for grant of regular bail to the petitioner in connection with Naharlagun Police Station case number 62 of 2025 under section 21 subsection B / NDPS Act subsection B / 29 of the NDPS Act. 21B and 29 of the NDPS Act. The fact of the case is same as the earlier one. You can write those part. Like you have written, right? Shaikh. Okay, you write the facts part. And then you say, lastly you say, the team, I think I have given like this now, on the statement made by Sariful Islam. The team, it's okay, I'll correct it. The team reached the particular place and apprehended 2 drug peddlers, and both attempted to flee. That part is also there. Both attempted to flee from the spot on the motorcycle. However, the police personnel apprehended both of them, and on search being made, contrabands were recovered from the co-accused, namely Shaikh Farid. Shaikh Farid. But no contrabands were recovered from the petitioner. the police registered the case. Then after you say that police apprehended both the accused person, police apprehended the petitioner along with other accused persons and lodged the ejahar and registered it, same thing, registered it under section 21B and 29 of NDPS Act. The counsel appearing for the petitioner submits that the petitioner is not involved in the aforementioned case and that nothing was seized. No contraband, not nothing, no contrabands were seized from the petitioner by the police on apprehension. He further stated that this is a bail application. No, you cut it. Nothing has been found. And on the other hand, Mr. Ite submits before this court that although nothing has been recovered from the petitioner, but he submits that in such a case, section 21 comes into play of the NDPS. Section 29 of the NDPS comes into play, wherein it is provided that whoever attempts, wherein it is provided that whoever abates or is a party to a criminal conspiracy is liable for the offense in question, even if nothing, under this such offense is committed. Whoever abates or is a party to the criminal conspiracy to commit an offense is liable, even if such offense is committed or not. He as such submits that the fact of the case is the petitioner was looking for clients and that his the co-accused, Shaikh Farid, were supposed to sell the contrabands to those clients. And as such, he submits that the petitioner is involved in the present offense. He also placed a judgment delivered by the Honorable High Court of Kerala in State of Kerala versus Muhammad Rias, R-I-Y-A-S, wherein the Honorable High Court had observed that section 29 of the NDPS Act is also can also get attracted in cases of bail. And also due to the fact, not due to the fact, and also would be applicable when the petitioner, when no contrabands are recovered from the petitioner. Heard the counsels and perused the case diary. It is noticed in the FIR dated 7th of May 2025 that on a information received, the police personnel had intercepted and apprehended 3 accused persons and the petitioner was one amongst them. However, it is noticed that no contrabands were recovered from the petitioner, although the petitioner was found in the company of the co-accused. the statement of the witnesses, more specifically, the informant recorded under 161 of the CRPC also reveals that he, along with other police personnel, during the raid and apprehension of the petitioner, along with the other accused persons, they could not recover any contrabands from the petitioner. Further, was nothing received, right? Then further, the case under which the petitioner is booked is under section 2021 subsection B of the NDPS Act, involving an intermediate quantity. Since there is nothing in the evidence showing that he was involved in the offense, although he was accompanying the co-accused, the petitioner for this court, for the interest of justice, enlarges the petitioner on bail on furnishing of a bond of rupees 20,000 with two local sureties, will do, with two local sureties of the like amount to the satisfaction of the investigating officer. Investigating officer case number is there. However, the bail is subjected to the following conditions. Number one, the petitioner would cooperate with the investigation of the case and would appear before the investigating officer as and when called for. The petitioner would not hamper or tamper with the evidence or influence any witnesses in connection with the said case. The petitioner will not leave the jurisdiction of the police station Naharlagun, right? Will not leave the jurisdiction of the police station Naharlagun without the leave of the investigating officer. Plus, this petition is disposed of.
My lord, only one humble prayer, my lord. Only observation of ground, communication of ground affairs may be reflected here.
You write the grounds, the mandatory grounds required under, unlike the other one, required under Article 22(1) as well as Section 52 of the NDPS Act 1985 has also been served upon the petitioner. That I will fit into somewhere. You write it.
Deeply obliged.
Petition is disposed of. Your judgment, Kerala judgment. Number 4050. Why two application? Chancellor, right?
May I please, Your Honor?
Yes.
My lord, here in this case, two bail application is pending, my lord.
Yes, yes. I can see
One,
that.
my lord, in two bail applications, the accused were since judicial custody 25/1/2024, my lord. And in both the bail applications, I have taken the plea of Your Honor violation of Section 50 CRPC, old section, and newly 47 and 48 of the BNSS.
Non-service of grounds.
Yes, sir. Yes, my lord. This was not communicated to the accused persons while making arrest of them. My lord. Both the cases.
Why two cases? Different offense?
Different accused. Different accused. Offense are same. Similar case. Same case, my lord. But one is bail application 76 is for the Manish Kumar Thakur, and bail application 2 is Manchal Kumar Manchal Kumar Yadav.
But then both are Chanchal, right?
Petitioners are same, my lord.
Acha.
Your Lordship, sorry for interruptions. Without wasting the court's valuable time, I like to advise this court regarding the notification, recent notifications. It is serial 1.
Okay, so before the same court.
Yes.
It was rejected.
There are 5 accused in this case. 2 bail applications were rejected by Justice Karnak. It's been
My lord, one thing.
Then let it be, let it be before the same bench, appropriate bench.
Yes.
My lord, the ground of arrest was not taken on that bail applications of that 2 accused persons, my lord.
Doesn't matter. I'm not going into the contents. If it is,
Arising out of same affair.
if it is, if the court is available and it has been passed by that court, it will go to that court only. There is a notification, I know, by the Guwahati High Court. So listed before appropriate bench.
Yes. Both these 2 cases.
Both this case will go to the appropriate bench. In view of the notification, no, need not go listed before the appropriate raised.
Yes.
Listed before the
Oblige.
appropriate.
Oblige, my lord.
Oblige.
My lord, this bail application may be as pass over for some time as the conducting counsel is attending another court.
Lordship, here, Lordship, we have called for the scan copy of the trial court report, but it has not arrived yet.
No, TCR is not here,
Yes.
so why do we wait? Let the TCR come, okay? It is reflected in the office note dated 2/7/2025 that the trial court records which was called for while order dated 25/6/2025 has not been received from the district session court's UPR. A reminder may be issued for sending the trial court list this matter after 2 weeks.
Right, Lordship.
May I please, my lord? My lord, this bail application file in connection to Itanagar WPS.
Case that is there.
Yes.
Yes, there.
Yes, Lordship.
Yes. My lord, before I made a brief act of the case, Lordship, I'll take to page number 14 in FIR, content of FIR copy, page number 13, my lord.
This is,
Just I read
he has
out
been
that-
inside since?
Yes.
He has been inside since?
Yes,
date?
since 4/6.
4/6 of this year?
Yes.
Okay. So not even,
Malad-
only a month, not
Yes.
even a month.
Not even a month.
My lord, page number 13, my lord. This is FIR, my lord. So I just read out the content of FIR allegation being made by the alleged victim. Subject complaint against Sri Techima shown up so and
Is it
so.
under POXO?
No, my lord, this is not POXO.
With,
Um,
64
I'm-
Lordship, 64 rape loss. 64.
64.
Rape.
The rape allegation, my lord. I am launching this complaint against one Sri Techimach, who is my ex-boyfriend, for physical abuse and assaulting me. This is the allegation, my lord. Physical abuse and assaulting me. I was previously in a relationship with a said person, but I was choose to end all communication with him and block his number after I discovered that he was having an affair with another girl. On 31st May 2025 at around 5 p.m., the accused confronted me at the shop of my friend at Naharlagan and told me he had something to discuss with me. When I refused to talk to him, he snatched my phone and dragged and pulled me towards his scooty and asked me to sit on his scooty and discuss the matter at my beauty parlor shop at the Naharlagan dam site privately. Since he was in aggressive mode and creating scene at public place, I sat on his scooty believing that he will take me to my shop. But shockingly, he started speeding his vehicle toward his private room at Bagetin Ali, food sale ground, dam site, despite my protest. When we reached at his place, he started shouting at me for ignoring his calls and blocked his phone, and he dragged me inside his room by pulling my collar and locked the door and tried to have physical intercourse with me. And
Order passed earlier. And the learned court. Recalled the interim order passed in favor of the petitioner on 21/2/2025. The petitioner. Where are the reasons of
Lordship, paragraph 2 is my reason, Lordship.
the petitioner submits before this court that he could not be present on the day when the criminal revision was listed, that is on 25/4/2025, due to his health issue. He stated that the counsel who is leading the case suffered from periodic paralysis which occurred sometime, and unfortunately on 24/2/2025, his counsel had this health problem and had to remain on bed, and he could not present himself on 25/2/2025. And that too, he was unaware of the date of listing of the case. As such, the counsel for the petitioner prayed for continuance and extension of the earlier interim order dated 21/2/2025 passed by this honorable court. Considering the issue, this court I'll think over and I'll pass the order into chamber.
Lordship.
Yes, Mr. I cannot, it's 5.
Your Lordship, one more order, last order, last order.
Mr. Methi, what was your matter? Now this is 5 o'clock. Now registry will give you time.
I want to mention one thing on it. Item number 22, Manoj, there is some mistake in the post title. Manoj. I may be allowed to correct now. Item number 22. Manoj.
22 is gone.
Yes, Manoj. But I have mentioned wrong. Manoj. There is some clerical error. I should have written 482. It is 482.
At the last sentence?
Yes, Manoj.
What? By hand?
No, Manoj. I will file an application. Manoj, that corrected page, Manoj.
Achha. The counsel for the petitioner is allowed to correct
Post title.
the cause title.
Yes, ma'am.
Cause title by filing a necessary application.
Manoj.
Maybe
Yeah.
let's say here, my lord, there's a, earlier occasion I saw in report. I saw in judicial report.
No, what had happened is you appeared.
I
And your
appeared.
NBW is gone. Now you are against
And not-
cognizance.
It was bailable warrant of issue.
Yes,
This honorable court modified the order on 30th. They appeared before this honorable court. On particular day, this matter was committed, and it is transferred to the court of session, as there is section 304 is there. So this
No,
order.
they committed the case to the court of session.
Yes, yes.
Now you file the subsequent application.
Yes, yes.
What you have prayed for here.
Yes, in this
Challenging the committed order.
committed order also the so far cognizance order and sursit also it is there.
So today I will issue only notice.
My lord, only my lord,
Interview will be hosted.
my lord, one thing, my lord, that's on that day also my brother misled this honorable court, my lord, regarding the affidavit is part concern, my lord. But if it is not maintainable, it was his or his my lord submission, my lord. I'm reading his submission, my lord.
No, not required. It's okay.
Yes, my lord.
No,
So far,
I'll issue
my lord, this proceeding may be stayed, my lord, unless because they are coming from the Jammu Kashmir, my lord. In every day, my lord, this cognizance without.
They don't have to come.
No, my
It's
lord. No,
committed.
my lord. My lord, what happened, my lord? Next day is for appearance, my lord, before the court of session, my lord. But here, my lord, without prosecution sanction, my lord, it is barred, my lord. The cognizance cannot be taken. Sursit also cannot be submitted, my lord.
No,
So, my lord, till that, my
only
lord.
this particular aspect I cannot give.
My lord,
Because cognizance, because sanction It may not be required, it may not be in the interest or in the.
Yes, yes.
No, my lord, no, my lord, it is mandatory, my lord.
My lord, project.
No, it is mandatory, but.
And this is
Mandatory, my
can be
lord.
raised during the framing of charges.
No,
also.
my lord, it is not.
So case is just committed now only.
No, my lord, no, my lord. It is wrong, my lord.
No, I will issue notice, it will be listed immediately.
My
after
lord,
the
this is also judgment, my lord, this is Ravina Kali, my lord. And I have also submitted another judgment before this.
No, today this is listed for the first.
My lord, from the second, first one is from second time, my lord, third time, first one, my lord, item of 3, and the item of 7 is first time.
It's already become.
No, not how it is impacts us. No, my lord, it is not impacts us. This state, my lord, the Supreme Court, I have to place one judgment also, my lord. Another judgment, my lord, place.
No, today this is the first time.
No,
And so
my lord, item number 3, I never.
You cannot force
My-
upon the court to pass orders.
My lord, sorry, my lord, I'm sorry, my lord, item number 3 is for third time listed, my lord.
Now this is past 5. Supreme Court has said on the other day, after
I
4:30, no
understand,
vote.
my lord, whatever, my lordship may bear one moment, my lord. The other day, my friend, my plea was, my lord, my the petition is not maintainable because it was affidavit was shown by some other person. So that ground, it was, my lord, listed on today, my lord. Item number 3, my lord. And the Honorable Court directed that without prosecution sanction, they can take up this matter or not. That was the order of this Honorable Court, my lord. So my friend has to satisfy that. When thereafter, my lord, I appeared as per this direction of the Honorable Court on 30th. Then the court committed the case and this.
Committal order you have challenged.
Yes, ma'am. Yes.
Committal order is an interlocutory order.
Yes, ma'am, but because of that, my lord, they see again I have to appear on.
And if it is a sessions tribal case, definitely it will be committed.
No, yes, then my lord, and without taking cognizance, my lord, without taking cognizance, without passing on
See,
section.
this is 5 o'clock.
My lord,
I will only issue notice.
My lord,
Your matter will be listed during the vacation bench if you want.
my small prayer, my lord. These people are coming for this Jammu and Kashmir border, my lord. And my lord, another thing is, my lord, this without prosecution sanction, there is so many. The apex court, I have placed.
It will be seen whether it is in discharge of official duty.
Yes,
Yes, so my lord, so much
hearing, my lord. Yes. Yes.
My lord, so my lord, there are present, my lord, I place in this judicial inquiry. Judicial inquiry by district judge.
But then today is right, Mr.
My lord, then the record may be called for, my lord.
Yes, SK Medi and heard Mr. So-and-so. Yes, this petition is filed against this petition is filed under section 528 of BNSS for, this is what?
Both the petition.
3. Under section 528 of BNSS for quashing of the charge sheet. You could have, you need not file this new petition, you could have filed a additional affidavit challenging the other things. Why new petition?
My lord, because of this, my lord, the direction was the appearance, my lord. Direction was the appearance, my lord, then it was committed.
It's okay, as well as the impugn order, as well as the order dated 5/6/2024, whereby the learned JM took cognizance against the petitioners and committed the case to the Court of Sessions, Papampare District UPA. Issue notice to respondent number 1, returnable by 3 weeks.
My lord, on 23rd, maybe. 23rd July, my lord.
You are the only respondent.
Only respondent, my lord. Issue notice,
No, then no, there are. Oh no, you are the only respondent.
Yes, ma'am.
Okay, then Mr. So-and-so appears for the sole respondent. So no formal notice is required to be served on him. However, extra copies may be given during the course of the day or within 2 days. And I call for the trial court records. Let the matter be listed on 21st of
23rd, my lord, July.
23rd of July 2022.
My lord, interim will be considered on the day.
Interim to be considered on the next day.
and my lord, in item number 3, maintenance will be also will be hard on that day.
My lord, this.
You raised that maintainability point. Okay.